Welcome to the Judicial Proceedings Committee. Before we get started today, it has been a long time since we've had anyone in person, and I just want to say that it is good to see you all in person. So welcome to our committee. It's actually been since March 2020 that we've had in-person committee hearings, so this is remarkable and refreshing. I'm glad to see all of you here today to participate in the process. Before we get started, just a few ground rules. If you could silence your cell phones or put them on or turn them off. Obviously, we've got you see that the seats are kind of one every other person, so keep that distance. Please don't sit directly next to another individual. When you're testifying and when you're inside of the room, please keep your mask on at all times, unless you're drinking or otherwise have another emergency that you need to attend to. And if your space, obviously the space is limited, so if you're not testifying on a bill and you know that folks are outside in the antechamber, if you could just be kind enough to let them in first, because we've got limited capacity, obviously. Otherwise, today is Tuesday, February 15th. We've got 12 bills on the docket. I'll read the order and then we'll get started. First, we'll start off with Senate Bill 450, 449, 451, 521, 384, 432, 485, 439, 469, 529, 435, and then we'll end with Senator Kagan at 486. So we'll start off today with Senate Bill 450. That's my bill, so I'll ask the Vice Chair to chair the committee while I go. All right, Mr. Vice Chair, I know we haven't done this in a while, but may I please bring my panel up? There you go. There you go. Well, good afternoon, everyone. For the record, my name is Senator Smith. I am here to testify on behalf of Senate Bill 450. You all are familiar with this bill because we passed it unanimously last year, and just to refresh your memory, I got the idea, or I heard about the idea for this bill because of an organization that my firm is involved with, the Metropolitan Washington Employment Lawyers Association. And during one of those meetings, it's a bar association, one of those meetings, this bill came up because New York and California and then Montgomery County had just implemented or just passed this legislation. So obviously most of us were here when Speaker Bush and then Senate President Miller had the task force and then promulgated recommendations for sexual harassment in the workplace. And building off of that work, that's what this bill seeks to do. Obviously, we've made a lot of progress here in the Assembly and throughout the state of Maryland, but workplace harassment is still a widespread problem, and there still need to be stronger protections. So this is something that, obviously, we're still very much in the midst of the pandemic that has become all that more important now, especially for lower wage workers and especially for lower wage women in the workforce. According to the EEOC, at least 1 in 4 women have been sexually harassed in the workplace, and harassment makes up 30% of all workplace complaints filed with the EEOC. So Senate Bill 450 clarifies that harassment can occur under the law even if it doesn't meet what the courts have called, and it's a judicially construed standard of severe and pervasive. So it alters the state article so that that level doesn't have to be met in our harassment article. So just some additional background. Title 20 defines harassment, and this is the way the statute reads right now, and includes harassment based on one's race, color, religion, ancestry, national origin, sex, age, marital status, sexual orientation, gender, identity, disability, and it retains its judicial meaning except to the extent that it is expressly or impliedly changed. That's what we're talking about. So when evaluating whether conduct is severe or pervasive to create an intimidating or hostile work environment, a number of the lower courts have interpreted this standard so narrowly that the conduct that I think anyone in this committee would find to be egregious just doesn't fall under that definition, that judicially construed definition. And a number of the organizations that are here represented today have offered testimony last year and this year. They have little vignettes of examples in case law that activity that all of us would find just abhorrent just doesn't qualify. And so that's the need and the justification for the bill. And specifically, I'd like to thank the Maryland Women's Law Center, the National Women's Law Center, and CASA here as well. And with that, I'll just go through a few of the mechanics. So it eliminates the need for an incident of harassment or sexual harassment to be severe or pervasive, as we discussed, when the terms and conditions of employment or an employment decision are based on the submission or rejection of that harassment conduct. So if you're at an interview or if you're going up for a promotion, if something happens, that's when this would apply as well. It ensures that an employer has engaged in an unlawful harassment or sexual harassment based on the totality of the circumstances as well. One more thing just to flag before, again, we worked on this bill, and I want to thank Senator Castley for his assistance with this as well, but one more thing to flag is that the MCCR and the EEOC have a work share agreement. So that means that the two agencies work together in processing these claims. And so you don't have to file with both agencies. You can file with one or the other. You can file with both. But if we change the standard here, there may be some incongruity with what the feds do. Just a flag, nothing that would prevent us from successfully implementing this law here in Maryland. So with that, I would ask for the committee's favorable report, and I'll turn it over to my panelists.
Good afternoon. It's so wonderful to see everybody in person. Thank you so much, Chairman Smith, for your leadership on this bill. Mr. Vice Chair, it's nice to be here. Thank you for having me. I'm Michelle Seary. I'm the Executive Director of the Women's Law Center of Maryland. And I want to just really focus, because I think Senator Smith did such a good job, Chairman Smith did such a good job on explaining what the bill does, what the bill doesn't do, just so that everybody is clear. So first of all, it does not in any way, oh gosh, I could stand at the podium. Thank you. Make it a little easier on the cameras, and my apologies. And I'm just going to start all over again then with what the bill does not do, because I want to make very clear that it does not in any way change the criminal harassment laws, right? This is simply addressing the civil harassment and sexual harassment, two very different animals. Additionally, it is already illegal to sexually harass someone or harass somebody based on their status in a protected class. This does not change that. It does not establish a new law. Employees still have to prove that the harassment was unwelcome and offensive. So there is still a very strong standard that they have to meet. And of course, they would have to prove that it was an unreasonably abusive or hostile work environment. So, and also for harassment alone, employees would still have to prove that it was based upon their status in that protected class. So again, it's not creating new protected classes. It is not creating new criminal laws. It is not creating new areas or changing the way that the plaintiffs would have to bring their cases. It does not create a civility requirement. That's really the important thing that I would like to understand. It does not create an anti-bullying in the workplace. It is simply streamlining and clarifying already existing law when it comes to sexual harassment and harassment. And so it also doesn't mean that these cases are automatically going to be found that the court has to now find in the employee's favor. It just means that the cases might get a chance to be heard by a jury or by the trier of fact if they're going before a judge. It just means that they're not going to be dismissed on a preliminary motion because of that outrageously high standard of severe and pervasive. So all it's doing is letting the jury decide. And for all of those reasons, we think it's going to really reflect the world that we are living in. It is going to modernize our current standards and mores. And for all of those reasons, we urge a favorable report. Thank you.
Good afternoon, Chair and committee members. Andrea Johnson with the National Women's Law Center and a proud resident of Silver Spring and Senator Smith's constituent. We've been supporting at the National Women's Law Center states across the country that are working to amend their laws in these ways and move away from the harmful, severe, pervasive standard. We strongly support this bill because that standard has been interpreted in Maryland in the Fourth Circuit in a really harmful way, an outdated way, such that cases that most of us would find to be egregious conduct are not given a full and fair hearing. In our testimony, you see a number of examples. Just one, a worker repeatedly making sexual comments towards another worker over a year and suggesting she be spanked. That was just kind of dismissed outright by the court. Or a male supervisor inquiring about a male employee's sex life, regularly commenting on his physical appearance, positioning a magnifying glass over his crotch, entering the restroom with him and pretending to lock the door and saying, "Oh, we're alone at last." Those are the kind of facts that I think we can understand are egregious but are not meeting the severe pervasive standard. This bill really simply ensures that Maryland's law is able to work as it was intended and capture bad behavior that no one should condone. And more states and cities are rejecting this standard. As we heard, Montgomery County here in Maryland in 2020, New York in 2019, California and New York City actually back in 2016. And it's important to know that this law is not as expansive as the New York or California laws. This is a bit narrower and rejects the unreasonably high, severe, pervasive standard, but otherwise still follows closely the federal law definition. So this is not a grand departure, but just really trying to bring the law back to what it was intended to do. I urge the favorable support of this bill, report of this bill, and put Maryland on the same path as we're seeing so many states this year, from Colorado to Vermont to DC, working to remove the severe pervasive standard. Thank you.
Good afternoon, Senator Smith, members of the committee. I'm Laser Goldsmith. I'm here representing the Metropolitan Washington Employment Lawyers Association, which Senator Smith referred to. We've got over 300 members here locally. Many of them practice in Maryland, some also in the district in Virginia. We're an organization of practitioners, and we're here to support the bill. It greatly simplifies the judicial analysis that courts would need to go through in adjudicating these cases, which we think is in the interest of all parties who come before the courts. It reduces the three complicated steps of analysis presently required down to just one, which is consistent with the broad and remedial purposes of the law. The old standard requires that the conduct be severe and pervasive, and that it interfere with performance or cause an intimidating or offensive environment, and that it's perceived by the victim as abusive or hostile. Those are all overlapping, they're complicated, and we have seen judges have difficulty with all of that. The new standard greatly simplifies to really encompass all of those ideas, but in a way that's fairer and more streamlined. So based on the totality of the circumstances, the conduct must create an unreasonably create a working environment that a reasonable person would perceive to be abusive or hostile. So by streamlining that way, we've removed words severe, pervasive, interferes, performance, intimidating, offensive, perceived, come to one simpler, fairer standard that we think is in the interest of all parties that will come before the courts, and accordingly, we urged ultimate passage of the bill and that a favorable report be granted. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. It is really nice to be back in this room. Thank you for your welcome, and it's really good to see you. The Maryland Coalition Against Sexual Assault supports Senate Bill 450. Much of what I would have said has already been said. It was my honor and privilege to serve on the Workplace Harassment Commission, and this certainly is a next step in this. Regarding specifically the issue of sexual harassment, please keep in mind that this is not, you have a nice tie on today, or I like your dress, or you're looking pretty. This is unwelcome sexual advances, requests for sexual favors, other conduct of a sexual nature. And I believe, Senator Castley, that we really owe you a debt of gratitude for that, debt of gratitude for the language. Based on the totality of circumstances, the conduct unreasonably creates a working environment that a reasonable person would perceive to be abusive or hostile. So there's a lot of protection for employers. There's a lot of protection for reasonable social interaction. Again, not bullying, not incivility. Just to remind this committee, made it through this committee, made it through the Senate, made it out of ECM, died on the floor at about 11:45 on sine die, running into traffic. So really kind of died a sine die death, but hopefully this year is the year that it would make it all the way through, and I hope it starts here with a favorable report on Senate Bill 450.
Excellent. Thank you very much, Ms. Jordan. And with that, that'll conclude the testimony for Senate Bill 450. We'll now turn to the committee for questions. Senator West, and then actually Senator Carter, I saw you first. Senator Carter, we'll go with you, and then we'll go to Senator West.
Thanks, Mr. Chair. Thanks for bringing the bill. So I understand that the bill had the unfortunate fate of dying on sine die. I've suffered that fate myself, but I've also come to realize that usually there's no accidents. Sometimes that's not exactly the accident that you think it is. My only question, and I'm sure I looked at this before, but I'm looking at it with new eyes now. So 2 questions. The exact language in this bill is taken from where? where's this language, where's the specific language in this bill taken from? What other statutes and/or states?
So it was originally drafted based, and perhaps Laser can speak a little bit more, based upon, I believe, the New York and Montgomery County, but then it was work grouped within the committee, and that was where some of the language came from Senator Castley, for example, on, to really streamline the bill from the original version.
Thank you. And so the one thing that pops into my head, because it's very non-specific, as I know it's intended to be, and no problem whatsoever with including non-severe or non-severe conduct, I am concerned because it doesn't specify at all that it has to be any type of a course of conduct or something that is continuing in any way. And so even though somebody testified that it wouldn't ever be just one off-color comment that could be subject to this bill, but I don't know that there's any language that would prevent that from happening, or is there?
Comment on that briefly. Already, using the judicially adopted standard, it's already possible that a single act can meet that standard, just as it could under any. It just depends how severe it is. So the Fourth Circuit had a case in which there was some very severe racial harassment or comments were made that were so severe that even though it only happened one time, it can meet the standard. But what's good about the standard here is that it's flexible enough that there is room for discretion without being quite so confusing as the existing standard.
Thank you. So you just exactly, I think, hit my slight concern that the one-time incident was actually severe, so it met the standard. But now we're talking about a non-severe, potentially one-time incident. Is that correct?
Well, the word severe would not be in the statute, but the other words that are here certainly would cover the need for it to be something that a reasonable person would perceive to be abusive or hostile. That's still a pretty stringent standard, I think.
Okay, thank you.
Thank you, Mr. Chair. So I took a look at last year's bill and found that we all unanimously voted for it, and it passed on the floor unanimously. So I'm not sure why I'm asking questions, but there is language in here which is a little confusing. So first of all, one of the witnesses said this bill would not change the criminal harassment laws, just the civil laws. What does that mean? Can you expound on that a little bit?
Yes, absolutely.
What would this bill change?
So this bill, it's dealing with the definition of sexual harassment and harassment that's currently found in state personnel and pensions, but it's moving it into state government Article 20, which is where it belongs. I mean, that's where our employment laws are in state government Article 20. And so it is addressing harassment in that context. Civil sexual harassment and civil harassment as in a hostile work environment based upon somebody's status in a protected class. So if somebody is making comments in a hostile work environment based on your race, your ethnicity, your religion, or your or ability or disabilities, that is what's covered. So I just wanted to make it clear that it has nothing to do with the definition of criminal harassment, which you might see in a variety of ways that would be prosecutable. It's a totally different animal. It just happens to have the same word of harassment.
So I gather what this does is it makes it easier for someone who alleged that he or she was subjected to sexual harassment to file a lawsuit and win monetary judgment against the alleged harasser, correct?
It makes it easier to survive an initial motion to dismiss.
Okay. Well, now, I've never been involved in these suits myself, even though I'm a lawyer, but generally speaking, my understanding is that it's very hard to win a motion to dismiss up front. So why under current circumstances, would it be difficult for someone claiming that they had been harassed to survive a motion to dismiss?
So, and I think some of the cases that are included in both MCASA and the National Women's Law Center are very instructive in this area, because what's been happening is that the courts have slowly been construing it so tightly that they have been throwing out these cases, just like Ms. Johnson was saying, cases where somebody jumped out of the bushes and tried to kiss one of their employees. That was thrown out because the court did not find it sufficiently severe or pervasive enough.
I see, so it's a matter of law.
Yes,
The
exactly.
court holds that the allegations in the complaint are not sufficient to withstand a motion to dismiss. That's what you're saying?
Exactly.
Okay. Has this language been enacted in other states?
I can speak to that.
Sure.
So, as I mentioned, New York and California have passed laws similar to this, and this was inspired in part by those laws, but this was intentionally drafted more conservatively, I would say. It follows in very large part federal law, as federal law is already interpreted in the federal courts, but just moves away, makes clear that the severe or pervasive standard, which has become over time just interpreted in such a high way that even continuing violations or a really horrible one-time violation are not being seen by courts as sufficiently as harassment. So it just moves away from that standard. But it's focusing on the intent of federal law and which Maryland looks to, which is how is this harassment impacting the work environment, and how is it, making it abusive and hostile for that employee.
I'm not sure I got an answer to my question. Are there other states which have enacted similar language to this, the reasonable person standard?
Yes.
Or will Maryland be leading the way in this regard?
No. So most of the time, states and the federal law do not, in the code, define harassment. It's been interpreted by courts. It's developed through case law. We're seeing a movement now to put it in the code because there's so much confusion around it. It's confusing for employers, for employees. Let's put it in the code. And so that's why, in part, but the reasonable person standard, the objective standard there is something that most states follow. It's seen in federal law as well. And so, no, Maryland would not be leading the pack in doing that.
Okay, so the totality of circumstances / reasonable person standard is used in other states?
Correct, yep,
Okay.
and in federal law, yep. It's just, this is trying to make sure that some courts, not all courts, but some judges have kind of forgotten about the basic principles of the totality of the circumstances analysis. What's required for the analysis, this is putting it in code so the courts don't forget that, and so it's clear to employers. But that is the standard. Totality of the circumstances is the standard. Reasonable person is the standard in federal law and state law. This is just making it super clear in the code.
Okay, final question. So in those other states which are using the totality of circumstances and reasonable person standard, have there been cases in which have triggered controversy because the employer or the alleged sexual harasser claims that the decision of the court has imposed serious monetary penalties on conduct which the harasser claims was not intended to be harassed? Now, inadvertently, because of the language used, the totality of the circumstances language and reasonable person language, the person alleges was used inappropriately in order to cause monetary damages to be imposed for conduct which they shouldn't have been imposed for.
I'm not,
Does anybody
Aware of
know
anything?
if there have been any, quote, horror stories in other states?
I'm not aware of.
I'm not aware of any horror stories. I haven't researched it, so it would have had to have reached me in a, more inductive sort of way, but no, not that I'm aware of.
Okay, great. Thank you for your answers.
All right, thank you very much, Senator West. All right. Seeing no further questions, thank you all very much for the panelists. That'll conclude the hearing for Senate Bill 450. We'll now move on to Senate Bill 449, and Vice Chair Wallstreicher. Mr. Goldsmith, you might be... All right, good afternoon, everyone. Senator Smith, for the record, here to testify on behalf of Senate Bill 449, the Unlawful Employment Practices Remedies. So we just heard a lot about harassment and some of the detrimental impacts that it can have on individuals and the workplace. What this bill does is that it raises the caps on compensatory damages. Obviously, these damages can be used as a deterrent for this type of behavior that we're trying to curtail. And what the bill does very simply is that it increases the limits on the amounts of compensatory and punitive damages that may be awarded to a plaintiff in cases of unlawful employment practices, which, if you look at, it's a two-page bill, it's all the graduated scales on page 2 of the bill. Now, this discussion, we came up with this because these damages, initially last year when I had the bill, it just removed the caps. And to my mind, and Mr. Goldsmith can correct me if I'm wrong, the caps have not been adjusted since 2007. And so, again, Senator Castley played a prominent role in figuring out how to do this, but what we did was we tagged the increase to inflation from 2007, and then we built in a 5% increase every year going forward, so we don't have to revisit the statute. And so that essentially is the meat of the bill. Again, page 2 is where you can see it. I can read this off for you, but you can see the employer size and then the caps that are being raised modestly, in my opinion. It's far overdue. And so with that, I'll ask the committee for a favorable committee report.
Hello again, Laser Goldsmith for the record with Mawila. A key provision of the bill is to gradually increase the caps on damages. The existing caps were, actually the numbers used were created originally in the Civil Rights Act of 1991, federal statute 31 years ago. In Maryland, they were adopted in 2007, as Senator Smith said. As we're all aware, inflation has eroded the value of a dollar considerably since then. Committee should consider that while these damages are in addition to lost pay, in many cases, Marylanders need to offset additional grievous losses. I've litigated many employment discrimination and other relevant cases, including some presently pending in Maryland, in which the plaintiff's life was turned upside down by sexual or other unlawful harassment, as we've been discussing with respect to the prior bill, or by disparate treatment discrimination, where availability of sufficient damages in addition to lost pay are necessary or is necessary. Some of the cases may never be brought because lawyers whom the victims consult may not view them as sufficiently remunerative. This improvement in the law may help with meritorious cases of severely disrupted careers or personal lives. In particular, I'd like to focus on the lowest end of the scale, an increase from $50,000 to $65,000 as maximum damages for an employee who has completely lost their career trajectory or might even be moved to suicide attempts or have other very severe emotional impacts is not an unreasonable increase by any stretch. I note that even at the high end, none of these altered numbers are that likely to have nearly the adverse impact on the wrongdoer as the positive impact that they can have on the victim who may really need the compensation. Frequently, entire careers have been upended, but the plaintiff is unable to find another job with similar pay, or is able to find a job with similar pay, but only pay. The career satisfaction or enjoyment of life or future opportunities may be gone. And some of these involve betrayals of the highest order. So I think it's well past time for an increase and would urge a favorable report. Thank you.
Excellent. Thank you very much, Mr. Goldsmith. With that, that'll conclude the testimony for Senate Bill 449. Turn to the committee for questions. Senator Castley.
I guess my question is the page 3 of the bill, line 11, changes the back pay eligibility from 2 to 3 years. Just trying to understand why that's done.
So I'll let Mr. Goldsmith go, but we did it because there's statute of limitations for sexual harassment's 3 years, right? Harassment's 3 years? And I'm asking the question.
It was extended, I believe.
It's 2 and 3. So we extended it to, I'll ask counsel, it's for harassment, it's 3 years? I think they have this written down. The other, 451, it's right here. So civil action, okay. So civil action that alleged unlawful employment practice occurred 2 years, and harassment is 3 years. So you wanted to make sure that you got back pay for the 3 years to capture both types of claims.
In a hostile environment or harassment case, it's because it's a pattern. It's a number of events have happened. There needs to be a benchmark for how far back the damages could go. So it's not unusual for a pattern to go on for years and years before it's brought to the courts. This is just adjusting that 2-year period where damages could be awarded, increasing it to 3, which is similar to the federal statute that was passed, the Lilly Ledbetter law and related statutes that have been passed in the last 15 years.
I guess what troubles me on that is that if there's an instance where something's going wrong, we want to encourage people to bring it up and not simply say, well, if I wait another year, I'm getting this is kind of running on me, and it's even more beneficial if I wait for 3 years and recover even more. It just seems that we want to encourage a public policy that says, if something's happening to you, bring it up now, don't wait for 3 years. And I'm just troubled by that.
But it mirrors what is in statute now for harassment claims, which have to be brought within 3 years. So that's why we wanted to mirror it
Oh my God, but there's not a benefit
for waiting.
for waiting. You brought it because when you could bring it, but there wasn't an incentive to wait for 3 years. And it just seems to me that we won't want to incentivize tardiness. We want you to bring it as soon as you can. And I mean, there's other people presumably in that situation. And by giving the lawyers, your chief legal advisor is going to benefit. The longer you wait, your lawyers increase,
The fee.
you've got a lawyer out there who's going to sit on this thing because my pay is based upon the harm to you, and so I'm going to delay for 3 years rather than resolve this in year 1 or 2, and we'll really go after it. That's what troubles me. Okay.
No, I hear you. Yeah, appreciate it.
I could just add briefly that if a pattern has been going on for a long time, then whether the back period is 2 years or 3 years, each day that goes by, the individual is losing a day of potential damages because they waited. So that's a countervailing point to what you said, Senator.
I'm sorry, I didn't understand that. You just, maybe layman's terms.
Sure.
That each day that goes by, they're damaged.
Sure, so let's say a pattern was going on for 5 years.
Right.
If the person files later, which is what your concern was, then they're only going back 3 years. So let's say they filed today, they can go back 3 years. Had they filed 3 years ago, they would have been able to go back 3 years from there, but there weren't 3 years of harm in the hypothetical. There were 2, so they could go back 2 years. So I think that kind of points in the other direction in terms of what the incentives are for an employee in that situation.
If I own a business and I got some jerk working for me, I don't know he's a jerk. He's a nice guy to me. He doesn't harass me because he's a guy and I'm a guy and he's harassing women. I want to know right away so I can fire the guy and move on, or at least confront it and investigate it. And I don't want any incentive for anybody to say, I mean, the worst incentive here is it's actually incentivizing the lawyer to say, let's just sit on this a little bit more because I got a whole nother year of damages coming in. So that's my concern.
I'm sorry.
I want fresh evidence and I want an immediate investigation. If you're being harassed, come to me now. Let's investigate, fire, whatever we got to do, and correct it. But we're incentivizing sort of dilatory conduct. All right.
I mean, just to completely clarify, I think that the employee who was the harassment victim in that situation does have an incentive to come right away in relation to the length of damages because the clock is available to them right then, and if they wait too long, there's going to be that cutoff. So I understand what you're saying.
Yeah, just prepare my lawsuit and sit on it. Okay, thank you.
Now, I would dig into what you're talking about, Mr. Goldsmith, is that a lot of the times this pattern or this course of conduct takes a longer period of time to kind of percolate to the top and then have someone come and be willing to come forward. And by that time, it could have been 5 years, 6 years, well past the deadline. But I get what you're saying. Okay, additional questions from the committee? With that, that'll conclude the testimony and hearing for Senate Bill 449. We'll now move on to Senate Bill 451. Vice Chair Walstrick, I'll ask you one more time. Good afternoon again. Senator Smith here to testify on behalf of Senate Bill 451. So you've heard a little bit about the harassment, you've heard about the damages. Now we're talking about the ability, the time frame for which you can bring this suit. So for a person aggrieved to bring a civil suit for unlawful employment practices, they have to first go through the administrative process. And once you've done that, you also have about 180 days before you can go to court. And so if you want to bring a civil suit. So right now, the time limit for the statute of limitations for that allegations begins when the act of discrimination occurs and does not exclude the time that it takes the agency to kind of go through the process. So if you've gone through the administrative process and it takes longer to investigate than you have for your statute of limitations, then you are precluded from going into court. And so what this bill does is it amends the state government article Title 20 by proposing that the running of the statute of limitations be told when an administrative charge is pending for the allegations of unlawful employment practices. So the language that I'm proposing here actually mirrors the language contained in the discriminatory housing section of the state article Title 20, which details an exclusion for any time taken for an administrative proceeding when computing the relevant statute of limitations, meaning that this change would make procedures for unlawful employment practices consistent with what we've done for violations of the fair housing laws. So with that, that's the bill. So with that, I'll ask for the committee's favorable consideration for adoption of the favorable committee report. And I'll stand for questions.
Laser Goldsmith for the record again. This bill would rationalize the interwoven systems of administrative handling of civil rights complaints and private lawsuits. Present law lacking this tolling provision requires an employee to terminate her administrative case and file her lawsuit within a 2-year period after the event that gave rise to the problem. Thus, there is what is essentially a statute of limitations for filing an administrative charge, and then, while that's pending, whether the case is an investigation or litigation or settlement efforts, another statute of limitations comes up for filing the lawsuit. This confusing scheme has the negative, or creates a trap for an unwary pro se discrimination complainant or even well-meaning but inexperienced lawyers. A victim may not easily understand that there's an absence of tolling during the administrative process, or may not even be aware of the limitations period at all, and may feel that by filing an administrative charge or complaint, there is nothing more she can or may do, that the matter is now in the hands of the government authorities responsible for adjudicating it. In the meantime, if the processing is slow, the clock will run out on the person's civil suit rights. This may result in potential cases being lost, but also in less likely resolution at the administrative level, because a complainant needs to file her suit to save her right to do so, thereby cutting off what might otherwise be an administrative resolution, either by hearing or by settlement. This bill fixes the problem. It incentivizes the employee to continue relying on the administrative process by not forcing her to early use or lose her civil rights suits, but it also allows the employee to exercise those rights suits within the segment of the 2-year limitations period that's retained by the or after the administrative processing. During this period, for instance, the employee who might have been pro se during the administrative process might find a lawyer, or more importantly, will be spared the present trap for the unwary. So on behalf of Mawila, I'd urge a favorable report. Can answer any questions.
Thank you very much. I'm wondering if you might be able to respond to the Maryland Chamber of Commerce's question that they ask. Says, SB 451 is unclear as to which administrative charge takes precedence in being finalized. Would the timeline for a complaint to be filed begin after the first administrative charge has been resolved? Or would all pending charges, potentially federal, state, and local, need to be resolved for the timeline to begin?
I wasn't familiar with the question before you read it. The question about the interplay with federal charges, which is a good question because the federal EEOC also has jurisdiction over a lot of these situations. I probably need to read that or hear it again to be able to address it. I don't know if the senator has an answer for it, but.
I can read it again. You have a response? Okay, sure. SB 451 is unclear as to which administrative charge takes precedence in being finalized. would the timeline for a complaint to be filed begin after the first administrative charge has been resolved, or would all pending charges, potentially federal, state, and local, need to be resolved for the timeline to begin?
That's difficult for me to address because I think the bill is pretty simple. Well, what it's saying, as to any Maryland charge that's been filed, it's told while it's being the time for filing a suit is told while it's being processed. In the District of Columbia, they've adopted a very similar provision. It, again, just says the timely filing of a complaint with the Office of Human Rights shall toll the running of the statute of limitations. It's very simple to follow and implement. I've had a lot of experience with it myself. That's really all this is. If you have a Maryland charge, the time for filing your suit stops while it's being processed administratively. When the administrative processing is over, by whatever means, then the clock continues to run. So if you had 1 day left at the time when you filed your charge in the first place, well, that wouldn't logically happen. But the point is, whatever time you lost, you would get back as a charging party and be able to file your suit after you see what happens in the administrative process, rather than incentivizing people to go outside of that process prematurely into court.
Okay, thank you.
I got to tell you, that's a really confusing question. Because I don't understand. I mean, just like Mr. Goldsmith, you can go through the timeline of like, so when you file, you go through the administrative process. You have to exhaust that first. But if you choose not to go through administrative process, you've got 180 days, right, before you can go to court and file civil action.
So there is a requirement that a charge be filed administratively. That is, it does need to be exhausted in that sense.
But if it's still pending, then you can go after 180 days, right?
Yes, yes. And so frequently, employees, once they've filed that charge, they may want to see that process through, and that may be good for the employer as well, because it's an administrative process rather than a judicial one. But the problem is that at a certain point, they've lost their right to file suit because they've opted to stay in that administrative process. And so if they want to have a suit, they have no choice but to stop the administrative process, even if it's right in the middle of something that might be productive toward getting the case resolved, such as a settlement attempt or something like that. So this kind of provision has worked very well in DC, and I would definitely urge favorable report.
It's much more beneficial for the employer in that side when you think about it, because there's an incentive to exhaust, to complete the administrative process, which may be much more efficient and less costly for both parties.
And for the employee, they just don't know frequently what to do, and so they, that can be the harm to them. But it's true that in the long run, if the employee is familiar with their rights, they may well just decide to opt out, whereas with this provision, they might stay in that administrative process, which might be good for the whole system.
Yes, thank you.
I'm sorry. Me? Okay, thank you, Mr. Chair. Now I'm a little confused. When I read the bill first, it sounded to me as if you had to start an administrative claim first, and then you can't do anything in the courts until at least 180 days have gone by, and then you can file a case in the courts. Does that mean that if you file a case in the courts, you have to terminate the administrative proceedings?
Yes, they're automatically terminated.
They're automatically terminated?
Yes.
Okay, gotcha, thank you.
Mr. Goldsmith, thank you very much. All right, with that.
Thank you all very much.
Thanks. All right, with that, that'll conclude the testimony in the hearing for Senate Bill 451. We'll now move on to Senator Hettleman with Senate Bill 521. Senator Hettleman, you're up.
Thank you very much, Mr. Chairman. For the record, I'm Shelley Hettleman, Senator from District 11, and I'm here today in support of Senate Bill 521. In its infinite wisdom, the Maryland General Assembly passed House Bill 18 last year, which guaranteed access to counsel for tenants who are going through eviction proceedings. Unfortunately, one thing we did not do last year was
ensure that the Access to Counsel Fund was actually funded. So this bill goes to that point, and what it does is it takes a percentage, the maximum allowable percentage of federal funding that is coming into this state, and it directs it to the Access to Counsel Fund. As you may recall, the Maryland Legal Services Corporation estimated that once up and fully running, the program would cost approximately $30 million a year. It's a 5-year period to get to that point, but we do have these federal dollars coming into the state at this point in time, and there is a certain percentage of them, 10%, that can be used for access to counsel. And so this bill just looks at the budget and captures the money. If the governor is including it in his budget through a special budget amendment, that we are putting the maximum allowable money in, directing it into that Access to Counsel Fund. So without further ado, I will be happy to answer questions or bring up others who would like to testify. Thank you.
Thank you. Why don't we bring up your panel, Senator Hettleman? And I'll defer to the chairman, but I think going forward, and I know we're all getting used to this again, if the sponsor can have their panel come up with them, I think that'll create more efficiency. Mr. Hill.
Thank you, Mr. Vice Chair. My name is Matt Hill. I'm an attorney at Public Justice Center. Public Justice Center supports SB 521 as part of a larger plan to fund the Access to Counsel and Evictions legislation. I won't repeat what Senator Hettleman said because I completely agree in terms of how this would work. My understanding is that essentially if the governor amended FY23 budget for rental assistance after July 1, 2022, then approximately 10% of those funds would go into the Access to Counsel eviction program, same for 24. Now, there's a few variables there in terms of whether or not the budget will be amended and how much that amendment would be. And so it's not entirely clear how much revenue this would generate for the Access to Counsel and Evictions Fund. But nonetheless, we support the bill as part of a larger, more comprehensive plan to fund the Access to Counsel and Evictions implementation. And you'll be hearing a bill next week that would transfer up to $11.8 million from the Abandoned Property Fund into the Access to Counsel and Evictions Fund. $11.8 million is the amount recommended by the Access to Counsel and Evictions Task Force in order to begin the first year of implementation. We estimate that that would assist approximately 9,000 families in avoiding disruptive displacement in eviction proceedings. And there's good reason for this, because we are still experiencing evictions in the state of Maryland right now. In the last 6 months, there have been roughly 700 families evicted each month in the state of Maryland. It's been shown that in one jurisdiction in Maryland, one study said that representation for tenants is 92% effective in preventing the disruptive displacement of families in eviction cases. And so for that reason, we'd ask for a favorable report on this bill, again, as part of a larger plan to more consistently fund access to counsel and eviction implementation. Thank you.
Thank you, Mr. Vice Chair, members of the committee. My name is Deb Seltzer. I'm the Executive Director of the Maryland Legal Services Corporation. The Maryland General Assembly created MLSC in 1982 and last year named MLSC as the administrator of the Access to Counsel program. When funded, this program will help tenants better understand their rights and responsibilities and also give them an advocate to guide them through what can sometimes be a confusing process. We look forward to building on the work of the Access to Counsel and Evictions Task Force, which noted support of the concept of this bill in its final report, paired with, as Mr. Hill said, another stable funding source. We are currently using other funding to set up infrastructure for this important program, including hiring a program manager, setting up an evaluation and data collection system, and working on other shared pieces of infrastructure that will help the program to run smoothly. MLSC is very grateful for the Department of Housing and Community Development's recent announcement that they would allocate approximately $5.4 million of emergency rental assistance funds to this program. We have already begun working with DHCD staff on this project and look forward to our continued partnership. If additional funds from this program called ERAP or other similar federal rental assistance programs become available, we encourage their deposit in the Access to Council Eviction Special Fund so that the program has an identified funding source during this implementation period. I would note that the federal government has released guidance and encouraged states to use this emergency rental funds in this manner, recognizing that pairing direct rental assistance with council makes the system more efficient and more effective. And with that, we'll ask for a favorable report. Thank you very much.
Thank you so much for your testimony. Questions for this panel? All right, seeing no questions, the next panel, Senator Casserly.
Just a quick question for the panel. So trying to understand this federal fund. So just to keep numbers simple, if the fund has $100 million in it, then Maryland can decide to use $100 million for rental assistance, or they could say $90 million for rental assistance and $10 million for legal fees. Is that what this comes down to?
10% can be used for housing stability services, which would include eviction prevention legal services. It could also include other housing-related services that DHCD could
But we
choose to
could
do.
use 100% of it to provide rental assistance, or we can take a percentage of that off
Correct.
and use it for these other things.
And there's also an administrative portion for the state.
And what's the you said equal to the maximum amount? Is there a current maximum amount for the feds?
There's been a total allocation through these kind of two tranches of emergency rental assistance of around 700 million, I believe. But much of the first portion has already been spent, and so it depends on whether it has been spent or allocated already. That's why this would only kind of take effect for next year if there was a budget amount.
No, I'm just trying, it says equal to the maximum amount of the federal rental assistance money that may be used. How do the feds determine that? Is there a percentage? It's what?
Up to 10%.
It is 10%.
Yeah.
I just made that up. Okay, it's 10%. I call it right, okay. And then somebody testified that 700 evictions each month. Now, was that statewide?
Yes.
And is that filings, or that's actually evictions that were not, there was no right of redemption asserted and people were actually put on the street? What does that 700 mean?
700 families put on the street.
So that's completed eviction statewide?
Yes,
Okay.
yes, Senator.
Thank
Each
you.
month, in the last 6 months of 2021.
And that data is from what?
It's from the court, the judiciary data.
That's from, okay, thank you.
Thank you, Mr. Chair. Ms. Seltzer, since the beginning of this situation, sorry, the podium does get in the way here.
You can come up to the podium if you like. We did that before. We're all rusty here, but
Yeah. Thanks.
thank you.
Since the beginning of this situation, I've been trying to get to the bottom of exactly how much legal counsel is going to cost in each of the, say, the next 3 or 4 years, and how much money is going to be available from federal funding in the next 3 or 4 years. And I've never gotten good answers to either question. So you're probably in the best position to provide the answer to how much counsel is going to cost. And what is your answer?
Sure. So we have projected for FY23 the initial cost for the entire program to be 11.8 million.
Okay.
Then FY24 would be kind of a little more than, or about twice that, so about 22 million.
Why would it be twice that?
Because we're looking to phase in the program, we would not be able to kind of provide coverage across the entire state all at once. We're also taking into account that right now eviction filings are lower than they have been. So we're kind of taking all those into effect. Now, these predictions may change once we kind of know what the perhaps new normal of eviction filings will look, and we'll have to adjust as that goes on. But that's based on, taking into account the current reduced filing and a phase-in period to where the bill says of October 1, 25.
Okay, and will the 22 million continue for the out years?
And then 30 would
30.
be, if filings went back to their 100,000 a year level. So if they never go back to that level, we think there will be a reduced, cost.
Well, now, there's a huge amount of federal funding available for tenant assistance.
Right, so that would be this pot of funding, that they can use 10% of it for
Right.
other
right.
services.
But the rest of it, the 90%, is going to be used for tenant
Yes,
assistance.
yes.
So I've always been assuming that with all that money available for tenant assistance, there won't be much need for legal counsel, because most of the tenants are going to be assisted with the rest of the money, and won't be in court.
That could be. There are also some circumstances where either they're not eligible for rental assistance or they may be working with a landlord who won't accept that rental assistance. There are also certain case types that may not be available or that are still eligible for eviction even with the rental assistance. There are also projections that some of that rental assistance will be out by the end of this calendar year in certain jurisdictions. So it kind of depends on the rate that those funds are spent and all of the other filings that occur.
Okay, you've been very helpful. So what you're saying is the numbers you've given us, 11.8 million this year, 22 million next year, 30 million the following year, you've taken all these factors into account, and this is your best estimate of what you're going to need.
Correct, and we will adjust in the future years depending on what the reality looks like.
Good, thank you.
All right, thank you both very much. We'll next have is Mr. Countess, and we'll hear from Ms. Hanson-Mundell, Mr. Washington, Ryan Washington, and we've got favorable with amendments, but we'll bring up Mr. Wiggins. Grayson, out of your favorable with amendments, you can come on up. Mr. Wiggins is up. Okay, sir.
Mr. Chair, members of the committee, my name is Gregory Countess. I'm with Maryland Legal Aid. I'd like to thank the committee for having this hearing and Senator Hettleman for introducing this bill. We've submitted written testimony, and we would rest on our written testimony. The only thing that we would say, and I don't think that this committee needs any urging on this matter because, you in fact did pass the Access to Counsel bill last year. And it's that this pandemic will mercifully end, at least I believe it will mercifully end, and with the pressures exerted on tenants with rising rents, and this goes to Senator West's point, the pressures exerted on tenants because of rising rents because of the market, this increase in rents will lessen affordability and increase the affordability crisis. There are all sorts of actions other than failure to pay rent that can be filed by a landlord in order to evict a tenant, and we don't have enough lawyers in order to represent folks in those tenant holding over and breach of lease cases. So it's necessary for us to be able to have assistance to help with failure to pay rents. So for those reasons, we urge a favorable report on Senate Bill 521. Thank you very much.
Good afternoon. Can you all hear me? Perfect. Good afternoon, members of the committee, Mr. Chairman, Vice Chairman. My name is Ryan Washington. I work as Government Affairs Manager for the Apartment and Office Building Association of Metropolitan Washington, also known as AYOBA. I just wanted to go on the record in favorable for Senate Bill 521. AYOBA supports a dedicated funding source to the Access to Counsel Eviction Special Fund that does not increase fees or impose any new fees on rental housing members in our industry. And additionally, we do support any language that clarifies the amount that may go toward the special fund. Thank you, and I'll be around for any questions.
Mr. Washington, are you in the Blake Building down in D.C. on the 10th floor?
No, yes.
Yeah.
Sorry, we have an Annapolis office.
My firm is on the other side of that. I'm not.
Oh, really?
Yeah. So,
Perfect.
Thought I recognized
Neighbors.
you. Yeah, there you go. All right, Mr. Grayson. Mr. Wiggins.
Good afternoon, everybody. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. It's great to be back in person. You have our written testimony. We are favorable with amendments, just asking that the committee consider a more close look at how much money is being allocated. The only reason we put that in is because we were given two different numbers from stakeholders. I'm going to agree with Mr. Washington. Most of you have heard me say this ad nauseum. This is a better funding mechanism than unrecoverable court costs that act as financial penalties for housing providers accessing the judicial system. Do want to clarify, just because it was brought up, that we do have questions and concerns that we have articulated most recently at the Access to Council Task Force about the budget that MLSC has put forward. But again, we are generally supportive of use of federal funds and state general funds for the program. And we do believe, again, that those are better use of funding than the unrecoverable court costs. Thank you.
All right, thank you very much. All right, so that will conclude the testimony for Senate Bill 521. No questions from the committee, so that'll conclude the hearing for Senate Bill 521. Thank you very much, Senator Hettleman. We'll now turn to Senator Hettleman with Senate Bill 384.
My panel to come up with me, please.
Feels good to say that, doesn't it? Your panel.
I know, in person. Good afternoon. For the record, I'm Shelley Hettleman, Senator from District 11, and I'm here to present Senate Bill 384 with my esteemed colleagues here, some of whom have very personal firsthand experience that I look forward to them sharing with the committee. This bill requires judges to pause eviction proceedings when a tenant provides evidence, and real evidence, that they have a request in for rental assistance and it's pending. As we know, and we've heard from many of our constituents, thousands of renters, and in fact, I just picked up a phone call this morning from a constituent who hadn't gotten her unemployment insurance yet, was notified by her landlord that she was about to be evicted. She had a request in for rental assistance, and this situation is repeated over and over again across the state. We know that people are still juggling childcare demands, and some of whom have lost their job, and we're very fortunate that the federal government stepped up and provided almost over $750 million in the state of Maryland to assist renters who are behind on their rents. So as you will hear in the testimony, each of our local jurisdictions stood up their own program to process those funds. Our larger jurisdictions got funding directly from the federal government, in addition to funding that was funneled through the state of Maryland. And other jurisdictions got money directly through DHCD. We believe, and I think folks up here would agree, that we do have enough aid coming into the state to address the backlog of rent that tenants owe their landlords. It's taken a while, and there have been delays, and each of 24 jurisdictions have 24 different ways of processing that aid. And it's been technically challenging. They've had to stand up whole new bureaucratic methods for assessing all of the information that they need to be able to get this aid out the door. What this bill does is it just gives a little bit of pause. It gives judges the authority, and they haven't had that authority, to be able to say, hold on, you're doing everything you need to be doing, renter, and your request is being processed by your local government, and we're going to give you a little bit of breathing space here and make sure that you are not out on the street before that rental assistance is being processed. We all want landlords to be paid. We want tenants to be able to stay in their homes, and this bill is really important to allowing that to happen. I'm going to stop here because these other folks have a lot of details that they can share with you and their firsthand experience, and I'm happy to answer any questions. I just think this is a really important piece of legislation at this moment in time to be able to help so many thousands of our neighbors, our constituents who are behind on rent. And we have the money to be able to address the issue. We just need a little bit of pause to help the bureaucracy move through the system. Thank you. Terry? Or Paul?
Hey, good afternoon, Mr. Chair, members of the committee. My name is DePaul Nibber. I'm here on behalf of the Maryland Association of Counties in support of SB 384. As of this morning, counties had assisted 40,095 households requesting emergency rental assistance, amounting to $249.1 million in total financial assistance distributed. This bill would address a number of issues facing county housing and human services officials with respect to the state's emergency rental assistance program. A recurring theme amongst these officials at this past Mako Winter Conference was that despite significant outreach, many rental assistance eligible tenants simply were not aware of the program. More time is needed to reach and assist these tenants, as well as their landlords. County governments have worked tirelessly, as you've heard from the bill sponsor, to identify trusted messengers and develop informational materials for landlords and tenants alike, essentially building these programs up from scratch. Moreover, there's been a number of outside influences contributing to delays in processing applications, including federal requirements that have shifted on a regular interval. For example, proof of income requirements and lease agreements have become significantly more relaxed over time, somewhat easing backlogs, but at one point in time it created a huge hurdle. In addition, county officials have experienced some pushback from a handful of landlords willing to accept these rental assistance payments. This bill is narrowly tailored to the rental crisis in front of us and includes a sunset date set in the near future. It will prevent our constituents from succumbing to housing insecurity, potentially resulting in damage to our social safety net. For these reasons, we urge a favorable report for SB 384. Thank you.
Good afternoon, Mr. Chair, members of the committee. I'm Terry Hickey. I'm the director of the Baltimore County Department of Housing and Community Development. I'm going to take a perspective from county government here that you've heard referenced several times. Here in favor of SB 384, it proposes a common sense solution to a very complex, really unprecedented issue. As has been pointed out, and will be pointed out in testimony coming, stays like this have been put in place all around the country. Some have been in place since nearly the beginning of the pandemic. They've become a proven and best practice way of providing consistency and order to a highly complex situation. Automatically staying proceedings for tenants who have already applied for assistance to local governments and putting some of that accountability on us to make quick response to those tenants is a way to allow our frontline legal partners, the ones that would be funded through the bill you just talked about, with the ability to serve more clients more quickly than spending a great deal of time in court now trying to negotiate individual mutual stays on a client-by-client basis, which is what is happening. What we don't have is consistency. Early in the pandemic, in the absence of an automatic stay, Baltimore County and others were forced to create their own systems. Luckily, in our county, the district court has been a partner since the beginning. They've provided to us copies of reserved judgments and warrants of restitution that we have to pick up in paper version every week, take them back, log them into a computer, and start calling tenants. Luckily, we get those. Some jurisdictions don't have the similar access, and so they're hoping the tenants come to them. When we receive an emergency warrant and we're able to contact the tenant or landlord, it takes our providers on average about a week to get an agreement in place with the landlord and in most cases transmit actual payment. What we need though statewide is a consistent process for doing this that landlords, tenants, providers, and attorneys can all hang their hat on. So in short, I will say we are here speaking in favor of this. It provides consistency across the board, lets us do our jobs, get money in the hands of landlords more quickly, which is what I think we all want to see happen. Thank you.
Good afternoon again, Mr. Chair, members of the committee. Matt Hill, Public Justice Center. Maryland has, as you've heard, sufficient rental assistance funds to pay all of the $392 million in estimated rent debt right now in the state. Yet, landlords have been evicting approximately 712 households per month in the last 6 months. Why? Because we've set up this nightmarish race between the rental assistance process and the eviction process, and oftentimes the eviction process is winning. SB 384 is the fix. SB 384 would say to the courts that you should pause an eviction case if a rental assistance application is pending. Currently, the courts have no authority to do so. Second, you should incentivize the landlord to take the rental assistance. Many right now do not. You're going to hear soon from Derek Strickland about the devastating effect on families when a large corporate landlord just can't be bothered to accept the emergency rental assistance. If the landlord is going to use a state-funded court process to evict the tenant, they should be required to accept state funds. SB 384 will end this nightmarish race and align rental assistance with the eviction process. And it is a best practice that's been adopted by 16 other states. In short, we can't accept business as usual in the middle of the COVID-19 housing crisis. We have to radically change how we do business in the state of Maryland, and that includes elevating housing stability over the corporate profits of landlords who are seeking a debt collection as easy as possible. Thank you.
Chairman Smith, members of the committee, thank you for the opportunity to speak on this legislation. My name is Alex Avdikov. I'm a staff attorney at Maryland Legal Aid. We support Senate Bill 384 because it prevents unnecessary evictions. I would like to touch on just two main points, addressing the two main prongs of the legislation. Point one, this would slow the eviction process. We have clients that are put out because rental assistance money does not come in on time. I have seen in my experience hearings 30 days, as soon as 30 days from the filing date. And in my experience, the average rental application takes several months to process in Baltimore City. And landlords are generally happy to accept rental assistance funds rather than resorting to eviction. This legislation gives the agencies time to get out the money. Point two, this fulfills the purpose of failure to pay rent eviction. A failure to pay rent eviction filing is essentially the landlord demanding that the tenant pay the amount owed or face eviction. Currently, a landlord can file a failure to pay rent eviction, then decide they do not want to accept the rental assistance and move forward with the eviction. And after they move forward with the eviction, they can then sue the tenant in a consumer debt case for the rental money that they refuse to accept. This legislation addresses those scenarios. It makes the landlords either accept the rental assistance money or seek another form of eviction. Thank you.
Excellent. Thank you very much for the panelists. We have a couple questions for the panel. I saw Senator Sidner, then Castley, but unless are you still? I thought you were going for it first. Okay.
There you go. Thank you. I had actually two questions, and this is for anyone on the panel. The first question, what I'm confused about is the landlord's ability to refuse payment. One would have thought that the Home Act would have taken care of that. How are they able to refuse payment with that law already in place?
I can take that one, Senator. I believe that it is prohibited under the source of income discrimination law in the state of Maryland. Unfortunately, not everyone shares my point of view, including certain members of the bench. And so this law would bring some clarity to that process.
Thank you. And the second question that I have, and maybe it's best addressed by Mako. I like the analogy that Mr. Hill made about the evictions running against the time that the county's getting the money out. But the question that I have is, what do we have that's going to incentivize our local governments to get the money out faster? Because I think I heard that with Baltimore City, it takes months to do this. So I guess we're expecting the landlords to kind of wait until they get the payment, because, the money's coming, but why does it take so long to get the money into the hands of the landlord to make certain that these tenants aren't put in this predicament?
So I think that our counties are incentivized just by virtue of these are their constituents. They want to make sure that they are taken care of. And, once a constituent is out of a housing stable situation, there are all sorts of other interventions that are going to be required of counties to ensure the safety and general welfare of these tenants. So I think that is the big carrot for our counties to ensure that these payments come out. But it has been a very long process to get these programs off the ground. You know,
But now but it's been now 2 years. Why is it taking counties so long to get the payments into people's hands? The program should be set up.
It'd be easier for folks if you could come to the podium as well. Just, we're all rusty here, but the camera is going to have trouble capturing you unless you're in there, and it's hard to wrap around. But.
Sure. Would leave if I could, just quickly, you're dealing with multiple streams of applicants in any one pool. So for instance, if you have eviction paperwork, if you have a court summons in your hand, even if you've never applied for a program in Baltimore County, we can get you referred and have the landlord paid in about a week. There are people that may be a single individual with owing a couple of months' rent with no children who may have been waiting in line. And admittedly, some of them have been waiting for a while, and we're trying to dig through the backlog, particularly when we reopened our portal and 4,000 people applied in 5 hours. So that's a case where we have to dig in. The truth of the matter is, we've been reduced to using those warrants as a safety net to catch up. And what's also being sacrificed in this equation is a real case management approach. It's all a race to get the money out and try to beat, I love Matt's analogy there, but what we're sacrificing is really figuring out what's going on with that family to avoid them having to come back for more assistance. A stay that gives a specific amount of time for the service provider to work with the landlord, to work with the tenant, I think would give us a chance to work that out. And honestly, it would hold us accountable. You build in a stay like that, in the states that have done this, it is up to those county programs to deliver that assistance and that guidance within that frame. And I'm willing for us to be held accountable for that.
And what's the average time in Baltimore County now?
If you were to look at the average amongst everybody waiting from the very beginning, and keep in mind, Baltimore County did intake forms, so we did a short mini application. So the average waiting time there would probably be 2 to 3 months.
Thank you.
If you don't mind, Senator, could I address that question too? I'd like to point out just what, it also reflects the fact that there really was no significant rental assistance program prior to COVID-19. So our social safety net had been cut to the bone so deeply that, and I rarely say wonderful things about county government, as Mr. Hickey knows, but it's amazing to build up entire infrastructures to deal out federal funds with federal, strings attached for $800 million in the middle of a pandemic is no small feat. And I think everyone, even in Baltimore City, will recognize that they're moving the money much more quickly than they used to. It just took time to build the infrastructure in order to do that because it didn't exist before. Thank you.
I guess I'll start off where Senator Sidnor left over and just ask, how does the stay, the implementation of a stay, hold a county government or any government accountable? Somebody explain what you mean by that.
So in other states, like I'll use New Jersey as an example, they crafted this early on in the pandemic as an eviction diversion program. So the landlords were free to come in and exercise their right to file the case in court. The tenant would follow the process. It would be stayed for a specific length of time. I think the national average is between 30 and 90 days. The local eviction program would be notified that that stay was in effect, and the clock was effectively ticking for that program to make contact with the tenant and provide aid. We've been doing it on a sort of a mixed basis of people coming to us. Some people apply when they're a month late. We have thousands of people applying because they're worried they're going to be late the following month for the first time, and our providers are trying to sort all of those out. I think this puts counties on the clock as being able to respond when we know that that stays in effect. And keep in mind, and I think lawyers that are coming up will be speaking to this specifically, you can do mutual stays. It's inconsistent from court to court, but you've got lawyers working with agents for landlords to try to negotiate stays anyway, but it's highly inconsistent. We're not always getting notice of it, and we're just consistently trying to keep up.
But how does that hold you accountable? How does the stay hold the county? Does the county executive have to pay some money out of his own pocket if the stay's not met? What's accountability means that there's a penalty of some kind, that if you don't meet the deadline, we would like to finish this meeting within the next hour. We'd probably go way beyond that. There's no there's no penalty for that. We'll just go as long as we have to. What about this enforces accountability?
I think being able to track the stays and the length of time it takes to get aids to tenant allows the public to hold the counties accountable in real time, using a consistent set of facts for how long it takes us to get aid to those tenants.
See, I'm confused on this, because the only one facing a penalty is the landlord. If the landlord had the ability to say, oh, give them the rental payment in 3 minutes, they would do it. But they don't have that power. The only one who's actually under pressure, who's legitimately penalized when this thing goes long, is the landlord, and they have no say in that process. They're the only one who's actually paying through the nose. So that's what I don't understand, how this is holding the county accountable, because quite frankly, we're only in this position because the county's incompetence. Let's face it. The counties are the ones in a position to actually make this happen. And now the county's failed on public housing, so that's no longer an option because the county screwed that up. So now we're at the mercy of the private landlords, who we come in here and say are greedy people. They're the ones pulling us out of the fire. And we're saying once again, let's penalize them. We have a problem here. Let's put, once again, for like the 20th time in the past year, let's put the burden back on the landlords. I'm trying to understand why. Why do we have the counties coming here saying, we can't do this, we're not efficient enough to get this done, and so let's burden the landlords one more time.
Sure. And I don't think I based my statements on the fact that we aren't able to get money out. I think that's been said. I think the landlords we work with, and we work with hundreds, we reach out to landlords. We're putting a system in place so landlords can begin to check or even begin their own applications. The landlords want some sort of a consistent rule as to how long these things are going to take. And I think this helps in that position. And I will just say this, accountability, when a tenant is evicted in our county and we need to go to deeper lengths to find stable housing for that family, I think that's a penalty shared by everybody.
Sure, but we've heard testimony repeatedly. We hear a lot of testimony on the land. We've heard unrebutted testimony that an eviction takes like 6 to 9 to even 12 months. So somebody knew 6 months before the eviction time that this tenant wasn't going to make this rent. And they knew it for month 1, and month 2, and month 3, and month 4, and month 5, and month 6, and so on 7th. And now we're in month 7th, and the eviction's beginning. They've actually finally gotten the order of eviction, and now the county says, now let's stop so we can spend another week. You just told me it was a week. Stop that all so we have one more week to get this in place.
Right.
And I'm just trying to understand, why couldn't you use one of those the 7 weeks, the weeks in those first 7 months to actually do this? Sounds really incompetent.
Well, because under the current system, the first official notice that we get is that pink piece of paper that we pick up at the court.
Again,
And that's
why
not
don't you
guaranteed.
change your system so you know in week 1?
That's a court issue.
That you can't work with the court, so you get notice in week 1.
This
I'm
is
sorry,
the result of
the
that,
filings
yes.
are all on record. The filings go up on the webpage the millisecond they go in. So you're on, they're there. All you got to do is have your people pull it up, download the files. You know who has filed what addresses, who the defendants are in the landlord-tenant cases. You know, to say, well, that's the state. You guys know, you have no public notice of who's been filed. There's nothing to prevent you from going to them at day 1 and saying, hey, rental assistance, here we are, and doing that. But instead of doing this, now we're once again, I just find it outrageous that once again we're coming in here saying, let's go after the landlords. People who have sat on debt, we're talking like tens, hundreds of millions of dollars in this state. They're sitting on the debt, unable to move it because the state repeatedly says, you're going to bear the burden. Not us, not the public taxpayers, not the public at large, but the landlord is going to bear the burden. And here we are once again back with this. I'm just trying to understand, because I see the counties in here asking for this, and I don't see you guys with clean hands in any way in this thing. Thank you.
And if I may add, Senator, the landlord does have other options.
You could come up to the mic, if you could come up to the, slow things down a little bit.
That the landlord can seek other forms of eviction and doesn't have to go
What's this
through
other
this
form
at
of
all.
eviction? You can't do self-help, you go through the statute. Tell me what's the other form of eviction?
A tenant holdover.
So let's let him stay for a while, then push it, okay.
That's all.
All right. Well, welcome back to in-person JPR. Let's help with this. So you spoke to, I think you spoke to the concept of a mutual stay. Can you expound, just before I go over to Senator Watson, can you just expound upon that a little bit?
Yes, so a mutual stay is when the landlord and tenant agree to a stay of the eviction proceedings for a certain period of time. And we often negotiate a mutual stay because it's often in the landlord's benefit. They can get paid, $8,000, $9,000, or they can move forward with the eviction and get paid nothing. And so often we can negotiate those mutual stays, but often we can't. We have a number of very aggressive, uncooperative landlords, corporate landlords, who are even refusing all rental assistance. And again, you're going to hear from a tenant who's experiencing that right now. And those landlords will not agree to a stay, and those landlords are aggressively moving forward with eviction, and that's why we need this bill.
So what is the financial incentive to not to pursue a mutual stay for the?
Mr. Chair, that's a great question, and I don't know the answer, so I hope that someone from the landlord community can address that. It seems to be some of the same that we heard in the debate over the Home Act. It's just an unwillingness to incur any sort of administrative burden that's going to entangle them, or some perception that they're not going to be able to be free to do exactly what they want to.
So, thank you very much. Sorry, Senator Watson, you're up next. Sorry, I just wanted to insert that because it was relevant to the line of questioning before.
Yeah, thank you, Mr. Chairman. This has been a very interesting discussion. This bill just leads me to believe that you're seeking landlords' help to pay for state dysfunction. And my question is pretty simple. You mentioned this was being done in 16 other states, and when somebody, I think Senator Sidnor, asked about average length of time, you said 2 to 3 months. What's the maximum time, based on your experience, that a landlord has had to wait for payment?
I think the maximum amount of time would have run into the several months. A big part of the issue that the counties are facing are collecting the information from both the landlord and the tenant. So our longest cases of waiting have resulted in having difficulties completing the required application form.
Right, so here's my issue. Because a lot of these landlord-tenant things, while I understand your intent, they harm those landlords who own 1 or 2 units. Why not instead, because you mentioned the term corporate landlord, somebody did, so I'm thinking multiple units. Why wouldn't you segregate this bill, because someone with multiple units can spread that cost while they are seeking to resolve these things with 1 or 2 tenants? Those who have 1 or 2 units that have to wait 3 months, 90 days, are in big trouble, especially if they're relying on that income, to keep things afloat.
Right.
And so, while I understand the dilemma, I think there has to be a distinction between this and a lot of the other bills that I've heard, between the mom and pop shops, I'll call them, and those ones like I talked to with our Attorney General, those big owners who are doing things that we'd like to stem. That needs to be separated, because this bill hurts people like me, who are landlords that have 1 or 2 units, and I know that's not your intent.
Right.
So I'd ask you to think about that a little bit. Thank you.
Very important point, and I just want to mention a number of the counties, many who won't be speaking today, have bifurcated programs like ours that work with the big landlords separately in a mass piece, and then try to focus that other portal on the smaller landlords. But it is a challenge.
Thank you, Mr. Chair. So I'm trying to get a handle on this. I see the testimony, which I will get, I guess, from Mr. Wiggins later on, from the Multifamily Housing Association, indicating that the time between a court filing and a court hearing for non-payment of rent cases is more than 1 year in some jurisdictions. Would this panel agree that that's correct?
No, absolutely not.
No.
Not to my knowledge, at least.
All right.
That's not the case in Baltimore City. There is a significant delay in Baltimore City. I don't know the exact length of the delay.
Well, so what is the longest time that expires these days between a court filing and a court hearing for non-payment of rent?
I mean, we don't have data on that, Senator.
So you
and
said
some-
it's not as long as a year, but you can't tell me how long the longest is?
Senator, so it really depends on jurisdiction. That's part of the problem.
Right.
I think you're going to hear from Lisa Sorrow in a moment that Anne Arundel County is moving, right on pace. They've regained their prior pace. Montgomery County, I understand, is moving a little bit more quickly.
Well,
yes, Baltimore City, some other jurisdictions, Prince George's County, are further behind. But it varies widely.
Isn't it correct that the courts haven't heard non-payment of rent cases since December?
Yes, well, so essentially January and February, they have not heard failure
And they're
to pay
not
rent
going to
cases.
hear any cases until March.
They're going to, I believe, it's like March 6th, I believe, the fair. So there's basically a 2-month period, what's coinciding with the peak of Omicron, in which, as a public health measure, the courts were restricted from hearing failure to pay rent cases until that Omicron has resided.
So I'm looking at the language of the bill, and it looks to me as if a tenant that didn't pay their rent in a county that, let's say, it takes 6 months to get a hearing in court, could not pay their rent in January or February or March or April or May or June, and when they get into court in July, they could have applied for this relief 2 weeks earlier, and according to this, the court would have to stay the case. And then we heard from the fellow from Baltimore County, it takes 2 to 3 months. So then we'd have July and August and September before the relief came to the tenant, and the landlord would be able to resume pursuing the case. Now, if in September, the landlord tried to reschedule the case on the court's docket, and that's another 6 months, we have then October and November and December and January and February and March before the landlord finally gets into court to try to collect the rent that came due the previous January. Am I wrong in this?
Senator, I think I got you up until the second filing, and then, yes, there would be a significant delay, but a lot of these landlords are filing every month. And so they're always only, essentially, you see what I'm saying? Like, there's a new case each month that is being heard, and so they're...
Well, I'm talking about the original filing in January for the unpaid rent on January 1st. It sounds to me as if the landlord could be waiting until March, over a year later, in order to be able to recover that rent per a court decision.
Senator, I think you're under the assumption that they're waiting 6 months to file the next case, when in fact they're waiting just 1 month to file the next case. And so, yes, they're behind, but it's not
I'm talking
behind
about the unpaid January rent. Under
I'm
my
sorry.
hypothesis, the underpaid January rent doesn't come to trial until July, and in July, the tenant had just applied for rent relief after
Okay.
6 months, and the court, under this, has to then continue the case, and if it's in Baltimore County, it could be another 3 months. That's August, September, October, and then when some relief comes, but not enough to pay the entire amount, the landlord then tries to reschedule the court case that got continued back in July, and it takes 6 months to get in court again.
No, Senator. So that
What am I
case-
missing?
I'm having a little nightmare back to law school, and the hypos are changing. But, so you've got this case that's filed in July. It's heard in I'm sorry, what month again?
October, I think.
October. Okay, so it's heard in October.
No. The case was filed in January.
January. So
It
it's
doesn't get
in
heard till July, because
It's
it
heard
takes
in-
6 months.
Okay, so it's heard in July.
Right.
And then it's continued for 2 months, let's say, and I think that's a long time for
I heard-
rental assistance to get
I
processed.
heard 2 to
think
3
it can
months,
be
but-
processed much more quickly than that.
Okay.
But then in July, so September,
Yep.
2 months,
Yep.
and the rental assistance has been paid. And so the rental assistance then will have paid from January through September, and the landlord's made whole, and no one is evicted. And in the middle of a pandemic, I just want to emphasize that these are not folks who've just chosen not to pay the rent. These are folks who are waiting on these unemployment insurance decisions that are taking forever. These are folks who need childcare and who have to stay home and have to quit work in order to take care of their children because their children can't go back to in-person school. I mean, my clients are just facing a host of problems that are just awful, just terrible, that no one would ever want to go through. And so this just pauses that eviction process to make sure that the rent is paid, the landlord's made whole, and the tenant's not evicted.
Thank you for your answers.
Thank you.
All right, further questions from the committee? That was a lot. All right, thank you all very much. Thank you. We'll go call up the next panel. Is Kane Levings here? Katie Davis? Lisa Sorrow? And Derek Strickland.
Thank you, Mr. Chair and members of the committee, for the opportunity to testify. My name is Kane Levings, and I'm an attorney with Disability Rights Maryland. My work is focused on eviction prevention in Baltimore City. I'm here to testify in support of Bill 384 on behalf of Disability Rights Maryland. No one should be evicted when there is money to pay the rent, especially during a pandemic. This is especially true for Disability Rights Maryland's clients. Our clients face significant loss of income at a higher rate during the pandemic than their non-disabled peers. This means that they are at a higher risk of being evicted if they don't have enough time to apply and receive funds. During my work at Disability Rights Maryland, I have encountered many individuals who have received failure to pay rent complaints that have not been able to successfully apply for rental assistance or who are waiting for rental assistance to be dispersed to their landlord. This creates a race to see if rental assistance can pay the landlord before the court trial date. A stay on proceedings fixes that unfair situation. For the disability community, accessing and utilizing rental assistance may be the difference between remaining independent in their own communities or being forced into nursing homes, state hospitals, institutions, or into homelessness. To reiterate, no one should be evicted when there is money to pay the rent. And because there is available rental assistance, I respectfully urge this committee to return a favorable report on Bill 384. Thank you for your time.
Good afternoon. Thank you, Chairman and committee members, for the opportunity to testify today in support of Senate Bill 384. I'm Katie Davis, the Director of the Pro Bono Resource Center's Courtroom Advocacy Project. Since 2017, we've been using our staff and volunteer attorney model to provide date of court representation for tenants in rent court. We currently have 6 staff attorneys plus volunteer pro bono attorneys representing clients in Baltimore City and Baltimore County and staffing a hotline 5 days a week. Since the pandemic began, we've represented over 500 tenants in rent court in Baltimore City and County and worked with hundreds more on the tenant hotline. So I want to give you a window today in just how this bill would help in court in real time. When we meet tenants in court for the first time, our first question is always, or since the pandemic, is have you applied for rental assistance? As the pandemic has worn on, it's more and more common to hear yes, but I haven't heard from them yet. So we use that information to negotiate with the landlords and try to encourage them to dismiss the case with the knowledge that if they do so, the payment will be forthcoming. If that fails, we routinely request a continuance in court in order to give rental assistance time to make that landlord whole and give the tenant the ability to stay housed. In reality, however, tenants often leave courts with a judgment, and our staff then pivots to working with rental assistance to try to expedite the tenant's payment so that they can pay to stay and avoid an eviction. Through a working partnership with rental assistance agencies, we've been successful in keeping hundreds of families housed in this way, but it shouldn't work this way. Families should not have to go through the stress and uncertainty of wondering when a constable is coming to show up their home, figuring out where they will sleep or how they're going to preserve their belongings if and when they do, or how they're going to get to work or get their children to school from a homeless shelter across town. As you've heard many times, there's money available to pay these rents, and no one should be evicted when there's money available, and more importantly, no one should have a judgment when money is available. For those reasons, we are in support of 384, and we request a favorable report. Thank you.
Good afternoon, members of the committee. My name is Lisa Sorrow. I'm General Counsel with Arundel Community Development Services. We are the Housing and Community Development Agency for Anne Arundel County. I've provided my written testimony already. I'm going to veer from my written testimony to address some of the issues that have been raised. First and foremost, that is that there is no way to prepare in advance for who is going to be evicted or when they're going to be evicted. Nothing is electronic. Specifically, you cannot file a failure to pay rent case electronically. Answers do not go on electronically. Writs are not filed or made public. We've pleaded with our court to have the writs, to get the writs, so we can prepare and we cannot. I've asked the sheriffs. The sheriffs have thankfully provided us with their eviction schedule. So we know where and when evictions are going to happen. We have no idea who is going to be evicted. We have the opposite of what Baltimore County has. Baltimore County has knowledge of who's at risk. They have no idea when that's going to happen, though. So from county to county, it varies. All the counties are making steps, whatever they can do, whatever information is available to them. Everybody's trying desperately to get that information so we can act in advance. The other thing, and this is an unintended consequence of focusing on folks who are scheduled for eviction, it is completely unfair to the landlords who are waiting. As a result of having to pivot and deal with the handful of landlords that are scheduling evictions, all of these other landlords have to wait, the small landlords included. We've got a program where we're focusing on the small landlords, but dealing with these emergencies is taking up so much time, and it's unfair to the landlords that are not causing these emergencies. Excuse me, I need some water. It's unfair to the landlords that are not causing these emergencies. Thank you.
Good afternoon. My name is Derek Strickland. I live with my wife, Tony Watkins, and our two daughters, Zoe and Joey, ages 6 and 2, at Western Apartments. There are over 150 units in our complex. The complex is managed by Apartment Services, which manages apartments throughout Baltimore metro area. Like many of our neighbors, some of which were our friends, family, have struggled to pay rent during COVID. Our landlord has refused to accept the rental assistance, and we were standing on the edge of eviction. Before COVID, everything was fine. I was working in a warehouse. Rent was paid timely each month. We were a two-income household, and we were able to send our oldest child, Zoe, to private school, so she could have the best education. When COVID hit, I had to quit my job to take care of our two children. They were forced to stay at home. My wife has been picking up many shifts as much as she could during the day at a grocery store and in the evenings at a local restaurant, and just frankly has not been enough. We managed to pay some of the rent that is due up until now through her wages and from borrowing money from friends or family, which is just another bill that personally we have to pay back. We are constantly receiving eviction notices, sometimes on a daily basis, and it's just, kind of harassing. But we're just basically paying enough just to stay in the property. We can't really dig out the hole ourselves without the help. We applied back in August, crossed our T's, dotted our I's with all the documents, gave everything we had, answered all the questions. We waited, told months later that the landlord agent was frankly just not participating in the program. In a single day, I probably removed maybe 3 eviction notices in a single day. But I don't know how much longer my family can, keep doing this. We just help it, everybody supports 384. Thank you.
So thank you very much, Mr. Strickland, and for the rest of the panel for taking the time to testify today. Senator Hettleman has a question.
Thank you very much for your testimony. Ms. Saro, could you just elucidate a little bit about the process? Because there was an assertion made earlier that all it takes is going to a computer and looking up and seeing what is being filed in the court. Can you talk about how landlord-tenant issues are different?
Yes,
in the court system,
I
please?
was listening to how the process was described, and I was thinking, oh my gosh, nirvana. That is what we would love to be able to locate. Right now, the landlords go to court with a stack of paper complaints that are filed. They don't make it into Maryland Judiciary Case Search for every county, and for those counties that they do make it in, it's often very much delayed. You cannot tell based on what is entered in Maryland Judiciary Case Search who won or who lost, and you can't tell if a writ has been issued. Sometimes it will say a writ has been issued, but there's nowhere that you can go and just look at who in your county is at risk of eviction. What we do in Anne Arundel County is our sheriff has provided us with access to a Google Doc that all the sheriffs that execute evictions they put when they're going to be at certain properties, and then we have to call all those properties and ask them who's on their eviction list. And sometimes they tell us, sometimes they don't. And then we cross-reference who they say they're scheduling with our wait list to see if those folks are if we can help them to process their eviction, process their application more quickly. And then we race to process that application before the sheriff goes and knocks on the door. I've asked for copies of the writs. I've asked for, we've asked for a lot of help that we're not getting from the courts. And if it were all electronic, things would be a lot easier for us. There is nothing electronic, and there is no way to find anything. Does that answer your question?
It does. Thank you very much.
Additional questions from the committee? All right, excellent. Mr. Strickland, I've got your email here. I'm going to follow up with you if that's okay. I'm not your senator, but I'd like to follow up with you. Thanks. All right, excellent. Thank you all very much. Thanks. Next, we've got one more panel before we switch to the opposition. Let's go to, let's see, is Alex, are you still here? Mr. Balcos? Yeah, come on up. And I know that you're translating for, nope, you want to come on up? Are you testifying on this bill? And is Angelica here? Yeah. Okay, come on up. And is Reyes, Miss Reyes? No? Okay, then we'll go on to, is Miss Mayhew here? Saw her out in the lobby, there you are. And Miss Amster?
Sweet, ready? All right. Good afternoon, Chairman Smith and members of the committee. My name is Alex Vasquez, and I'm here today on behalf of CASA, the largest immigrant rights organization in the Mid-Atlantic region, representing over 120,000 Black and brown immigrants. As a community organizer, I spend my weekends canvassing neighborhoods with a high volume of failure to pay rent cases and pending evictions. With each conversation, it's clear that many tenants are still having difficulties paying rent and utilities on time. The pandemic brought millions of people in this country to the brink of eviction. It exposed just how many people are one job loss, one medical bill, one paycheck, and one emergency away from losing their home. For many, a pending rental relief application is their last hope. And as it stands, there is no statutory authority for the court to pause the eviction process related to renting assistance. Thanks to our efforts, we have saved hundreds, if not thousands, of Marylanders from eviction. We can attribute this to many renters applying, high approval rates for rental assistance, the continued flow of funds, current tenant protections, and my personal favorite, excellent community organizing. However, we must not be complacent, but instead proactive. Let's continue to keep our families in their homes, and that's why I'm here today and ask that the committee issue a favorable report on Senate Bill 384. Thank you.
Good afternoon. My name is Angelica Sanchez, and I am also a Montgomery County resident. The pandemic significantly impacted me as a single mother of 3 beautiful children. Despite my best effort to make rent payment on time, I fell behind and to start making tough financial decisions. Fortunately for my family and me, we were able to apply for rental assistance, which was approved after Tenant attorney applied pressure to the court, speed the process. This bill that approved and the 8 months it took, my landlord did everything possible to evict us. while the application was pending. To make matters worse, they ignored health code violation and refused to do any maintenance in hopes that we would give up and self-evict due to the unbearable conditions. I am here to support Senate Bill 384 because for many of us who unlimited get approved, it is the last line of hope that we can stay in our homes. It is our vision of eviction memorable against negligent landlord and overwhelmed and highly backlogged system in cases. That is why I ask that committee issue favorable report in Senate Bill 384. Thank you.
Good afternoon, Chair, members of the committee. Natasha Mayu here on behalf of the Baltimore City Administration in support of Senate Bill 384. Pre-pandemic in Baltimore, 1 of every 10 renters had arrearages. This was higher than the national average of 1 in 20. In April of 2020, that number was 1 in 5, and by June of 2020, that number was 1 in 3, with disparate impacts on low-income Black and Latinx households. We established our eviction prevention program in face of the sheer volume of evictions that were coming through in the pandemic. We have received 27,000 applications and have 5,000 in the queue. Given this sheer number, we prioritize those that are most at risk of eviction, and we work very hard with our partners to provide help and resources. This bill is important. It ensures that those seeking help in good faith have time for their cases to be reviewed. It allows us to continue to do that work with our tenants and our landlords to provide the necessary resources and assistance, whether that is mediation, legal support, reviewing of existing debts, and other needs. We are committed to trying to prevent as many evictions as possible. And so with that, we do request a favorable report on Senate Bill 384. Thank you.
Chair Smith, Vice Chair Waldstreicher, and members of the committee. I'm Molly Amster. I'm the Maryland Policy Director and Baltimore Director for Jews United for Justice. And I'm submitting this testimony in support of Senate Bill 384 on behalf of JFJ, which organizes 6,000 Jews and allies from across the state in order to support local and state social, racial, and economic justice campaigns inspired by our Jewish values. Jewish texts are full of conversations, laws, and traditions about the obligations of landlords and tenants about making sure that people can remain housed in particular. For example, the Talmud teaches, the Talmud teaches that a landlord cannot evict a tenant during the rainy season. Surely a pandemic would be a similarly important time to protect people from being homeless. It is unjust, cruel, and contrary to Jewish values to rush toward eviction when there is a less drastic alternative which could avoid eviction altogether. In particular, when there are public resources available to keep people housed, we must align the systems of government to allow those resources the time to work. To do otherwise is both a moral failure and a policy failure. Earlier today, I sent an email with information about how to email legislators in support of this and other housing legislation, and got an email back right before the hearing started that read in part, "I appreciate this email from you. I needed to email our legislators. They really need to pass this. I'm a single mother with 2 children. I lost my job due to the pandemic, and my landlord sent a sheriff to deliver an eviction notice. And they want me to leave in my apartment in the next month. I've been trying to pay my rent with the help of the county and other organizations. I only owe rent for January and February. This woman is fearful that she'll be evicted while awaiting rental assistance, and she has reason to fear, despite the fact that we have hundreds of millions of dollars to help people like her. You can change that by passing this legislation. We appreciate Senator Hettleman's sponsorship, and we urge a favorable report on SB 384.
Excellent. Thank you very much. All right. Questions from the committee? Seeing none, that will conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll bring up Mr. Wiggins and Ms. Howard.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins on behalf of the Maryland Multi-Housing Association. I want to quickly provide context on the delays we're seeing. Contrary to what Mr. Hill said, yes, there are jurisdictions where the time between a filing and a hearing is more than a year. I'm shocked that he denied that and said he didn't have any data to support his denial. But what it may come down to is that Mr. Hill's association represents about 200 tenants a year. We house more than 500,000. So, and we also have landlords across the state, obviously. So when you talk about delays and stays and things like that, I want you to understand that housing providers are holding the bag right now for, in some jurisdictions, as long as a year, in other jurisdictions, 6 to 8 months. And Mr. Hickey from Baltimore County comes in here and says that landlords got to have more time. They need to extend more time. I don't know, how long do we need to wait? I'm not sure how long Mr. Hickey wants us to wait. You know, our bills are coming due. There are no bills to stay, or there are no legislative bills to stay the payment of our bills right now. I would also note that there was a lot of discussion about the stays in the bill. I want to point you to page 5, line 26, which requires landlords to essentially sign whatever contract is put in front of us. So I brought examples. Rental assistance is accompanied with a contract. Some of these are extensive. And it's not as simple as just taking the money. Now, from our perspective, most of the landlords we know, in fact, all the ones that I've had conversations with, are participating in the programs, in large part because we participated in the development of these contracts. We negotiated in good faith as partners at the table. What MACO now wants you to do is to throw all that out the window and say, whatever we put in front of the landlords, they have to sign. There are prohibitions in these contracts. There are requirements in these contracts. If you pass this bill with that provision in it, these provisions could change on a dime. I would note that the House bill does not have that provision in it, so that's an interesting thing as well. We would ask for an unfavorable. Happy to take any questions.
Good afternoon, Mr. Chair, and it's very nice to be back in person in front of everybody instead of on little boxes. I'm Kathy Howard. I am Vice President of Regional Management, Inc. We are a landlord in Baltimore City. I just want to say that I think that you should give us a badge that says you did something good for a change. We have not filed a single failure to pay rent since the pandemic began, other than on people who had pre-existing debt prior to the declaration of the pandemic emergency. We are participating in both the Baltimore County and the Baltimore City eviction prevention, and we are participating in the ERAP and all the other assistance programs. One of the things that I think that we need to talk about in this bill is, and I think that the judiciary has some testimony on this that is written, is that it takes away judicial discretion. In particular, because it says that the court shall give a stay, as opposed to may give a stay. There has been a program in place during the pandemic where there was a reserved judgment program where you would go to court, you would determine how much rent was due. The judgment would be reserved until after the either the end of the pandemic, or we could now add this to this bill until there is a determination of eligibility. I think that would be a lot of comfort to landlords and make a lot of this angst go away over this bill. Mr. Wiggins is absolutely correct that the landlord grant agreements are some have some very draconian issues in them. And I would lastly like to make sure that we look at the bill and we take out the paragraph on page 5 that talks about if you don't participate, you do not get to use the courts. That's not how our Maryland law works. And I don't think that that is a needed provision in this bill. And we would ask you for an unfavorable report unless we can work something out.
Thank you very much. So Senator Huff, and then we'll go to Senator West.
It's a question, or I guess a follow-up to Mr. Wiggins. You said in some jurisdictions it's taking a year. Can you
Exactly.
explain a little bit? I mean, is that because the courts have been closed, or what is taking a year, and where is that happening?
Yeah, so we're seeing it mainly in Baltimore City most recently. In Prince
Uh-huh.
George's County, we've seen cases extend now well beyond a year. We're hearing reports of 12 to even expectations of maybe in 14 months at some point in the near future. It's a combination. So courts have essentially changed the way they operate. They're now running multiple dockets. And so you're not getting a large number of people in the courtroom, so courts are processing through cases much slower than they were previously. Additionally, you have court delays and court closures, which have created backlogs as well. As Senator West noted, courts were closed back in December, and they're not going to reopen for non-payment of rent cases until March 6th.
So
at the
if you
earliest.
live in one of these jurisdictions, you could have not paid your rent, and you can just wait it out in court for 12 to 14 months, is what you're saying, without paying rent?
So most leases that we see are a year in length.
Yeah.
And if you were to sign a lease tomorrow in Prince George's County and not pay any rent, it's very likely that your lease would end before you could get a hearing in court.
So you can get a year rent-free, huh? That's a pretty good deal. What is it taking in the other jurisdictions across the state? What are we looking at as far as backlog? Just
Yeah, we're seeing
curious.
Montgomery County has been as high, I think, as 10 months. Baltimore County, we've seen as high as 6 months. We've seen multiple month delays. Recently, Anne Arundel County has spiked back up to multiple months. Like I said, courts are closed right now, so March 6th is a whole new backlog to start working through, and we expect to see more delays because of that.
Just find it interesting, we hear proponents and advocates come in and talk about how draconian and unfair and terrible our system is, yet it appears that people are basically going 6 to 12 months without having to pay rent before they even get to the court. So seems to be the system seems to be to the opposite of what was testified at great lengths. I'll just say one thing too. I noticed people who kept saying, "Stay in my home." Seems we have a basic misunderstanding of private property rights. They don't own it. I actually don't own my house. The bank owns it. If I stop paying my mortgage, the bank gets to take it back. And a number of people said, "Stay in my home." It's not theirs. If you all own the property, it's yours. And so the system seems to be working in the state so that people are staying rent-free for a year. Am I missing something in these jurisdictions?
Well, it's interesting. Yeah, you make a good point. Our bills are due. It's also interesting, and I think really a testament to housing providers in this state, that housing providers, despite these long delays, are still working with tenants and applying for rental assistance. I'm gonna quote the gentleman from Mako right here, who said they've seen a handful of landlords say no to the rental agreement.
Yeah,
A handful.
and if you don't own the buildings outright, if you have a mortgage for your buildings, if you don't pay, what happens to your property there that you're renting out?
Well, that would be between the landlord and the bank, unfortunately.
Yeah, the bank would come and take it, right?
That is accurate.
Oh, interesting.
And I would note that if you want to take a look, the Department
Does the
of
state,
Labor.
is there any provision in here? So when the landlord goes bankrupt because they can't collect rent, is there anything in here to help the landlord fight the bank? Do you get any attorney fees or anything in any of these bills?
No, there's not.
There's
And
not, huh?
I'll note too that, we're not eligible for that homeowners assistance fund from the governor because it's not our primary residence. I would also note that if you look at the chart on a month-by-month basis, the number of evictions are doing this, the number of notices of intents to foreclose are doing this.
All right, thank you.
Thank you, Mr. Chair. Mr. Wiggins, during the hearing, I've roughed out a possible change to the bill. Suppose the bill read, notwithstanding any other law, if a tenant presents evidence satisfactory to the court that within 10 days after receiving the landlord's 10-day letter, the tenant contacted the rental assistance agency identified in the 10-day letter and applied for rental assistance, and that the tenant is currently waiting for a determination regarding the application, the court shall, et cetera, et cetera, et cetera. Would that be more acceptable?
I think we'd be willing to have that conversation. You make an interesting point, and that is that residents, as of October 1st, are required to receive a 10-day notice from the landlord, alerting them that the rent is unpaid and that they may receive a filing after 10 days. And so it's critical that tenants reach out to landlords during that time so they can apply together. Because remember, we are not allowed to apply unilaterally.
Right.
If the tenant isn't participating, there's nothing that we can do. We're not allowed to apply unilaterally and get rental assistance on behalf of a tenant who's not responding to us. The tenant has to be involved. That's federal law, not state law, so we can't make that change. I'd love to see it change, but we just simply can't make it. And so, yeah, I think you make a great point, is that the tenant has to be involved, and it needs to be as early as possible.
Yeah, so there may be a way to work on this bill to require the landlords to cooperate, the tenants, to cooperate with the landlords in applying for the assistance in order to expedite the money coming as quickly as possible.
Yeah, we're certainly willing to have that conversation. I would just point out again, though, that that page 5, line 26 is a problem, especially when it sounds a lot like this is really an issue between the courts and the advocates, and them not being able to share information.
Right, got you. Thank you very much.
Mm-hmm.
All right, well, it seems like we've had this deja vu conversation where, like, this is an ecosystem where tenants, they rely on jobs to pay their rent. The rent, you got to pay your lenders, and a lot of the financial institutions hold interest for pensions and other financial interests for people's future, their financial future. So we're obviously operating in an ecosystem. So I wonder, Senator Hettleman, maybe you could convene some folks, go to work on this. Really appreciate the opportunity to work something out.
Mr. Chairman, if I may, I would like to thank, the sponsor did meet with us beforehand, and we would be happy to have conversations with her.
No, thanks. There's a path forward, but figure it out. Thank you all very much. All right. All right, well, with that, that'll conclude the testimony and the hearing for Senate Bill 384. We'll now move on to Senator Klossmeyer with Senate Bill 432.
Thank you, Mr. Chairman and members of the committee. Senate Bill 432, it's called Baltimore County's Orphans Court Judges and Surviving Spouses Pensions. Senate Bill 432 would require the Baltimore County enable orphans court judges and their surviving spouses to receive a pension after completing 2 terms in office. This legislation would only apply to judges who have been in office on or after January 1st, 2022. Current law provides for most orphans court judges in Maryland to receive a pension, but some counties, including Baltimore County, are specifically exempted. Senate Bill 432 would put Baltimore County orphans court judge benefits more in line with those provided by the other large jurisdictions in Maryland. In addition, orphans court judges are currently the only elected officials in Baltimore County who do not receive a pension. With Senate Bill 432, we aim to increase benefits for those important public service to ensure that qualified candidates continue to want to serve in Baltimore County. I am accompanied by Baltimore County Orphans Court Judge Juliet Fisher, who will share more from her perspective, and I thank the committee for their consideration of Senate Bill 432 and ask for a favorable report. Okay.
Thank you. Good afternoon, Mr. Chair and members of the committee, Senator West, Senator Hettleman. I'm Juliet Fisher. I'm a Baltimore County Orphans Court Judge, and I have been since 2014. I'm here on behalf of my colleagues William Evans and Arthur Frank, who are unable to be here today. This is a hopefully relatively simple bill that brings Baltimore County's Orphans Court judges in line with the other major jurisdictions in the state of Maryland, all of which have a pension provided for them at this time. This bill was crafted mostly to reflect on the PG County and Baltimore City pensions that those judges receive. As Senator Klossmeyer said, we are the only Baltimore County elected officials who don't receive one, and one of the only judges, as we're specifically excluded. I don't know when 2108 of the Estates and Trust article was crafted, but certain jurisdictions were included. Most of them are provided for in other portions of Section 2108. And just for your knowledge, Baltimore County opens more estates than any other jurisdiction in the state. We actually opened about 1/6 of the total estates in the entire state last year. So it is an extremely busy jurisdiction. We have more hearings than any other jurisdictions. We sit 5 days a week. We're there full days. And so we would ask for the purposes of keeping and helping to get other people to give up other professions to make our pension in line with those of our comparable jurisdictions. So I ask for your favorable report on Senate Bill 432, which is cross-filed with House Bill 585, both as Baltimore County delegation bills. And I'm happy to entertain any questions.
Thank you, Mr. Chair. At the delegation meeting on Monday, we discussed this bill, and I know a letter, I'm sure we will support it, and a letter will be forthcoming. But we also talked about a possible amendment to include the single retired orphans court judge that we're aware of in Baltimore County.
There's actually 4, but 3 of the 4 are receiving state pension benefits as they moved on to state positions.
Right.
There's only 1 I'm aware of who doesn't currently receive a pension. I have, of course, not opposed to including my other judges in that. We were trying to keep it simple for fiscal and other purposes to just kind of start with the current slate of judges, knowing that certain of the other judges have moved on to either state judiciary or state elected official positions.
If the delegation's in favor of adding the one.
I'm not opposed either way.
Okay, great, thank you. That's it. Appreciate it.
Anything else?
There we go. Thank you, Senator. Any other questions? That concludes the hearing on Senate Bill 432. Thank you, Senator Klausmeyer. Senator West will now move to your bill, Senate Bill 485.
There we go. Great. Oh, I forgot. Yeah, of course, of course. Okay, great. Yeah, I'm so used to testifying sitting down. It's been 2 years since I've been standing up. Mr. Chair, members of the committee, it's a pleasure to be here with you to present Senate Bill 485. This past summer, Senator Watson and I were on a task force to study the Maryland's orphans courts. And we met probably, 7 or 8 times, and rendered a report. This bill represents 2 of the recommendations of the task force, and Senator Watson and I are co-sponsoring this legislation. Maryland's orphans courts are the state's probate courts. Interesting, most people don't have any idea what orphans courts are about. They think they're about orphans. In a way, if you were back 250 years ago, you would understand that in those days, the term orphan referred to anybody whose parents were dead. And so most people who die, their parents have predeceased them, and so they are literally regarded as orphans, or were 250 years ago. The definition of the word has changed, but the court's name has not. So orphans court judges do not relate to orphans. They relate to people who pass away. The orphans courts in Maryland supervise the handling of estates and have jurisdiction over the guardianship of minors and their property. Under the Maryland Constitution, the voters of each county except Harford and Montgomery counties elect, for a term of 4 years, 3 judges to the orphans court of their respective jurisdictions. In Harford and Montgomery counties, the orphans courts are presided over by circuit court judges. Currently, elections for judge of the orphans court occur during the gubernatorial election year, and candidates are nominated in the primary election. The nominees of each party are listed on the general election ballot along with their party affiliation. In most counties, candidates for orphans courts do not have to be lawyers. If a lawyer is elected to an orphans court, Maryland law currently restricts their practice of law or not, depending on the county involved. In most counties, once sworn in as an orphans court judge, a lawyer cannot act as an attorney in any civil or criminal matters during the attorney's term in office. However, in Baltimore City, Baltimore County, Howard County, and Prince George's County, a lawyer elected to the orphans court can continue to practice law so long as the matter is outside the jurisdiction of the orphans court and is unrelated to the administration of an estate or guardianship. So that's the current law. The two proposals contained in this bill embodying two of the recommendations of the task force are as follows. Senate Bill 485 would change the law in two respects. First, the bill provides for orphans court judges to be elected on a nonpartisan basis. In my experience, and I've been around a while, I can never recall a partisan issue in an orphans court. There simply is no Republican versus Democrat in the orphans courts. It's a better way or a worse way of doing things, but there's no partisan element to it. Candidates for this election would, without party designation, file certificates of candidacy by the first Monday in August. Then they would appear on the November ballot without party designation. Thus, a candidate for orphans court judge would not appear on the ballot in a primary election and would no longer be nominated by a political party. Second, Senate Bill 485 would repeal the county-specific practice of law restrictions and would establish a narrower prohibition applicable to all of the counties in Maryland. The bill would prohibit an orphans court judge from acting as an attorney at law in a civil or criminal matter during a term of office if the matter is one within the jurisdiction of the orphans court in any county, and two, related to the administration of an estate or a guardianship of a minor. So judges would be able to be elected to the orphans court and could continue to practice law in all areas without impediment, except you can't practice in the orphans courts and you can't practice law relating to the administration of estates or guardianship of a minor. That would prevent conflicts of interest. So now there are three possible changes to the bill, which I want to explain. First of all, the bill currently provides that it takes effect on October 1st. That doesn't make any sense. We'll be in the middle of an election, and we can't adopt a bill which would change the conduct of the elections in the middle of the election. So we either should make the bill take effect really quickly or on January 1st, 2003. So the bill as drafted, we need to change the implementation date. And again, we can discuss that back in the work session. Secondly, the Carroll County Registrar, Paul Zimmerman, who will testify in a minute, has suggested that we should, instead of pursuing the provision in the bill for the new election of judges, where they file on the first Monday in August and they get listed on the general election ballot, he suggests we should elect them like circuit court judges, like we do with current circuit court judges. So they would all file. All the candidates would appear on both parties' lists in the primary. Each party would vote for three. If the three match up, then there'd only be three names on the general election ballot. If Republicans were to nominate a different person than the Democrats, then maybe four judges would appear on the ballot in November, and the voters would vote for three. That would be acceptable. I think my idea is a little better, but I think Mr. Zimmerman's idea should be considered. And finally, the Orphans Court Judge Juliet Fisher, who is right next to me, is concerned about tie votes. The bill provides that tie votes would be filled as in the same way vacancies would be filled, namely by appointment of the governor. And she suggests that we would limit the governor to appointing one of the two candidates who got tied for the vote and prohibit the governor from appointing some independent person who didn't run in the election or fared more poorly in the election than the two tied candidates. I think that makes sense. So with that, I will turn the proceedings over to Judge Fisher and Mr. Zimmerman.
Good afternoon again. I am Juliet Fisher from the Baltimore County Orphans Court. I am testifying in my individual capacity with respect to this, and I'm also testifying on behalf of Judge Athena Malloy Groves, who is an Orphans Court judge from PG County, who was on the task force with the Register and with Senator West. So some of the remarks are hers. I incorporate them as if they were my own. With respect to the amendments as proposed by Senator West, I am in agreement with the amendments. However we can be nonpartisan, we need to be nonpartisan in the elections. In fact, the Annotated Code of Maryland Election Law Article, Section 5203B1, states specifically that a candidate for judicial office shall not file their party affiliation. we should not be filing our party affiliation. I'm really not sure why we are or why we have, but we're required by our county boards of election to do so. So I strongly have supported that. I've supported that for many years personally. With respect to the slight change about the date, yes, of course, it cannot apply to this election. I will just state to Senator West, a lot of us have already filed, so I really would prefer to start after this election because some election things are already underway at this point. Just following along with Judge Groves, the Constitution declares the Orphans Court as a judicial office. The suggested amendments to the election law article ensure that the orphan court judges remain neutral in the election process, as all judges should. Additionally, with respect to the practice of law, all orphans courts are by nature part-time courts. In Baltimore County, we sit individually, we sit 5 days a week, but we're not all there. We have one courtroom. In the small jurisdictions, some of them sit one morning a week, and they get paid commensurately with that. And so for those jurisdictions, and I will say that Calvert County is also allowed to practice law. So I would suggest that it will improve the bench to allow attorneys in all jurisdictions to have the uniformity to run as orphans court judges the same way that we can in the larger jurisdictions. And thank you for your time, and I'm willing to answer any questions.
Thank you, Judge. Mr. Zimmerman, come on up. You're actually not technically signed up to testify today, and we've been asked to take a hard line on that. You're here, you're already on the panel, so if perhaps you can testify briefly, but it's an exception we're not going to make frequently here.
Okay, well, thank you.
Thank you.
My understanding was I had been signed up for the panel, but, good afternoon, Mr. Chair, committees. This is one of those times when I wish I was a ventriloquist so that I could talk and drink water at the same time and thus not wear a mask, but that doesn't work, so. I'm the Register of Wills for Carroll County. I am the president of the Register of Wills Association, and I'm also a member of the task force to review the Orphans Court. And since the Register of Wills don't have a dog in this fight regarding these particular ones, I'm speaking from my position on the task force. We totally agree with the fact that that the prevention of practicing law for the other counties that are not a part of the specific ones named, that should be dropped so that it would be applied equally all over the state. So any attorney can serve and still practice law without giving up his practice anywhere in the state, with the exceptions of these conflicts of interest. With regard to the nonpartisan, we're in favor of that also. I don't have a problem with that. The only issue, as Senator West said, was with regard to the general election, because if you've got a whole crew of people running in the general election, you could end up with 3 people being voted in with less than 10% of the vote. And it makes more sense to winnow it down. And right now we've got, there's no other place in the United States that I'm aware of that has just people going into a general election. The one that we had talked about was the one where it's the same as the circuit court, where if you win both sides, then you automatically go in. If you don't, then there's a runoff in the general election. The only other one that gives us an idea or a pattern is the Board of Education, where if there are 2 openings in the Board of Education, the top 4 finishers then go into the general election. So that's just an alternative, but I think since they are judges, just as the circuit court judges, then I think that one way with the cross-filing would be the best idea. And I'm willing to answer any questions anybody has. Thank you all very much for your time.
Thank you. Questions for this panel? Looking around, I see no questions. That will then conclude the hearing on that bill. Senator Carrozza will next go to your bill, Senate Bill 439. Senator Carrozza. Oh, yes, please bring up your panel.
Thank you, Mr. Vice Chair. For the record, Senator Mary Beth Carrozza. I'm proud to represent Somerset County. And I am proud to present to you this local bill, Senate Bill 439, which would simply increase and provide updated salaries for specified elected officials in Somerset County to stay competitive with its surrounding counties, including Dorchester, Worcester, Wycomico, Caroline, and Kent, and makes a minor modification to increase the daily allowance for the traveling expenses of the Chief Judge and Associate Judges of the Somerset County Orphans Court. You will hear from Mr. Gene Atkins, who's traveled all the way up from Somerset County. He's the Finance Director, and he will share additional information and be able to answer any specific questions regarding the salaries and traveling expenses. Mr. Vice Chair and members of the committee, I respectfully urge the Senate Judicial Proceedings Committee for a favorable report on Senate Bill 439, a good, solid Somerset County bill. I thank you for your kind attention and consideration of this local priority bill. Thank you.
Good afternoon. Thank you very much, Mr. Chairman, Mr. Vice Chair, and committee members. For the record, my name is Gene Atkins, and I'm the Finance Director for Somerset County. I am here today representing the county commissioners who are strongly in favor of passing Senate Bill 439 to change the salaries of many elected officials in our county. This bill is necessary because these salaries are only changeable by law, since we are a county commissioner form of government, and they are also, I might add, only changeable during a specific window of time. The purpose of this bill, as Senator Croza has stated, is to bring the mentioned salaries more in line with that of our peers and with other counties. Most of the salaries mentioned in the bill were last changed 4 years ago, but the county roads commissioners and the orphans court judges' salaries were last changed back in 2008, so you can see it's been quite a while. Somerset County salaries historically run behind those of other counties. And that is once again evident when you look at the state's attorney's salary schedule, which shows that it is $16,000 less than the other shore counties prior to this bill. The Somerset County Commissioners respectfully request a favorable report and final passage of Senate Bill 439, and I'd be happy to answer any questions you might have about it.
Thank you for your testimony. Questions for the sponsor or Mr. Atkins? Seeing no questions, thank you, Senator. That concludes the hearing on Senate Bill 439. We're going to go slightly out of order here and go to Senator Benson for Senate Bill 529. Senator Benson, come on up. And please feel free to bring your panel with you.
Good afternoon, Mr. Vice Chair and members of the Judicial Proceedings Committee. Today, I present to you Senate Bill 529, a bill that is important to the health and well-being of Maryland citizens. The primary purpose of this bill is to reconstruct the process in which a tenant will notify a landlord that their dwelling contains bedbugs. Consequently, the act of reporting the presence of bedbugs requires the landlord to obtain an inspection. Additionally, the tenant should retain sufficient evidence that the landlord received the notice. Once the information is received, the landlord should, within 96 hours of notification, order and obtain an inspection of the dwelling unit by a certified professional. Once the dwelling unit is inspected and determined to contain bedbugs in any stage of life, the certified applicator should report the written findings to the landlord within 24 hours of the inspection. As soon as possible and practical, the landlord should provide the tenant with the written inspection results. In addition, if the inspection determines the presence of bedbugs, the landlord should immediately inspect all continuous dwelling units on the property. However, if the inspection determines that no bedbugs are in the reported unit or any of the continuous units on the property, the owner should inform the tenant that they may contact the local health department about any remaining concerns about the suspected presence of bedbugs. Furthermore, if the inspection does reveal the presence of bedbugs in any stage of life, the landlord should commence reasonable measures within 5 days of receiving the written notice from the certified applicator. These measures should include how to effectively treat the bedbug presence and the steps required to retain the services of a certified applicator, to treat the dwelling unit and any continuous units owned by the landlord. Now, ladies and gentlemen and wonderful friends, you all know that I am an educator. I'm an educator by profession, and I'm proud of it. One of the finest decisions that I ever made in my life was to become an educator. I share with you that I am both disturbed and heartbroken by the experience of a third grader who has been affected tremendously by bedbug infections. Let me just tell you all what happened. Last week I was sitting in my office listening to my committee getting a report. Got a phone call from a principal. You'll pardon me, I might just get real upset about this, but when I think about what happens to children, it just hurts me to even talk about it. It really does. The principal was crying, and she said, listen, Senator Benson, you got to help me here. I hate to disturb you, but we have this child who's been attending school here and attempting to learn while continuously scratching the numerous bedbug bites on his body. She indicated to me that that baby had bites on his face, his arms, his legs, and the scratches were bleeding. I want you all to think about your own children as I talk to you about this. The bites that occurred at night while he was sleeping had become bloody scars and scabs on his body. While basic measures such as spraying and even removing the bed covers and the mattress were taken to exterminate the bedbug problem, they did not alleviate the issue. No child or family should have their daily life, their health and well-being disturbed by bedbugs and not have the most effective and proper measures taken to diminish the problem. I might want to add that when this principal called the manager at the apartment complex, they didn't take it serious. And they said, well, this is a problem that the family has to take on, and they have to spray the apartment. They went on and on. She said, that's not solving the problem. This problem is really serious here. We need to do something about it. And with that, the manager said, well, you have the best way. Call the health department. And she gave the dear mother several avenues to explore, but to no avail. Studies from Chicago have shown that the bill's structure to productively reduce bedbug populations while also adding the benefits of minimizing evictions. Maryland has become a state with obsolete bedbug policies, thus ranking the Baltimore and D.C. metropolitan area 5th and 7th on Orkin Pest Control's top bedbug cities. Maryland's current outdated laws allow landlords to place blame on tenants, as I forestated, for tenants as opposed to taking care of the problem. So, ladies and gentlemen, this kind of behavior is called fault-based standards and causes disputes and delays treatment of bedbugs, making the problem harder to solve and even more costly. Additionally, trying to find the immediate problem of a bedbug infestation, especially in a multi-unit facility, is nearly impossible to do. And so, my wonderful friends, this bill will ensure that proper measures are in place and taken to handle bedbugs for tenants in the state of Maryland. It limits the neglect a landlord could have if bed bugs are reported to be in the dwelling unit, while also giving tenants and landlords a guideline to follow to best secure the health and safety of the living spaces in which they occupy. Bed bugs are a public health crisis, and they do cause a variety of physical health, mental health, and economic consequences. Tenants should not be subjected to such dangerous conditions with the expectations and paying to live in safe and clean environments. Thus, I would ask that you please urge a favorable response to Senate Bill 529. It really is very heart-wrenching when you think about the fact that our children have to go to school and be subjected to having to deal with bed bugs, and you have a principal who cares about her children having to call all over the place to get little or no response. But once Senator Benson got on the phone, and most of you know me very well, I got on the phone and I called the county executive, the health department, and everybody else that I could think of. Within a few hours, they did arrive at the school to talk with the principal, and then went to the apartment complex, only to discover that the bed bug infestation was in 4 apartments, which meant that they had to say to the landlord, this is what you have to do, and if you don't do it, something is going to happen. So I really want to commend the county executive and the people in Prince George's County who responded. One Senator Joanne C. Benson got on the phone and made the necessary phone calls. But I shouldn't have to do that. I'm too busy down here taking care of our business. I shouldn't have had to get on the phone and call Lottie Dottie and everybody to get them to do what needed to be done. And when you think about our children, they should not have to come to school under conditions such as having to sleep all night long with bed bugs. As a matter of fact, when they went to the apartment, the family had moved the mattresses out of the bedroom, but the children were sleeping on the floor, so you still had the same problem with bed bugs. So we do have to do something about this problem, and the people here who will be speaking to you this afternoon are the experts who know about this, but you also will have some people who don't see this as a problem, as they did in Prince George's County. That's why we have to help them by putting some legislation in to help them. So thank you all very much. I am certainly available to answer any questions.
Excellent testimony, Senator Benson, and thank you for your presence and your work here. We'll now switch over to unless there are questions for the sponsor. Senator Lottie, Senator Dottie, and Senator everybody. No questions? All right, there we go. Thank you very much, Senator. We'll now switch over to your panel.
Thank you. I hope you all understand my passion, and please pardon me for almost crying in here today. But when you think about children and the fact that they're not given their fair share, they didn't ask to be born, we've got to take care of our children. And if we don't have to worry about a future because there won't be one. So thank you.
No, thank you, Senator. We appreciate your presence and your work. All right. We'll move on to, let's get up with Mr. Countess, Mr. Hill, and Mr. Greenfield. I saw it came in. And that's it.
Good afternoon again to the committee, Chairman, members. I'd like to thank Senator Benson, Patterson, Lee, and Sidnor for introducing this bill. My name again is Gregory Countess. I'm with Maryland Legal Aid. And I really would only like to make 2 points here, 3 points actually. One, this bill is really necessary because it provides a process, a guide, both to landlords, to tenants, as well as to the court, about how you tackle what is a really difficult problem, and that is the issue of bed bugs. One of the problems has been is that folks are kind of squeamish about bed bugs. And so when you start talking about you have bed bugs and you want to have your home inspected as if you are in fact the tenant, you may have difficulty in getting an inspector to come into your home because everybody gets freaked out about bed bugs. This is number one. And so inspection and verification of the problem are really, really important. And that's what this bill does. Two, units that are contiguous to the unit that is in fact infested. It's really important that this bill in fact provides this process and procedure in terms of, one, if you find it in a place, that you inspect the units that are contiguous with it, because this leads to a solution to the problem instead of passing the problem along to a neighbor. Because eventually what happens is that you have the entire, perhaps you have the entire building being infested when it may have started only in one home. And so, again, we would ask for a favorable report on this bill. Thank you very much.
Mr. Chair, members of the committee, again, Matt Hill, Public Justice Center. It was the fall of 2014. I was minding my own business, staying out of trouble. I was not picking any fights with any senators, when a client came into my office with terrible orange blotches all over her arms. She said that her teenage son had the same. And they couldn't sleep at night because every time they woke up, the blotches were worse and they were even more itchy. And so it was causing them significant mental distress, physical distress, and we filed a case for rent escrow because the landlord refused to address the bed bug issue. I had no idea what bed bugs were. It was a journey for me, it was a journey for the judge, it was a journey for the housing inspector. And so I've attached the opinion from the judge in that case. It's actually a former MSBA president, Judge Mark Skirty. And he found that bed bugs are indeed a threat to the health and safety of residents, and that it was the landlord's responsibility to fix the bed bug problem. I think if I can emphasize one thing, it is that current laws and regulations do not adequately address bed bugs. Because I think, as Senator Benson was just saying, they're set up to address issues that are a fault, right? If you have mice in your house, it's probably your fault because you're a bad housekeeper. I mean, I think that notion's way outdated and wrong, but that's the assumption underlying a lot of our regulations. Bed bugs are different. Bed bugs can be found at a homeless shelter. They can be found on a hotel on Fifth Avenue. They are no one's fault. They just travel with you. They're not a product of poor housekeeping or poor hygiene. It is a massive problem, and if it's not addressed quickly, it spreads. And it spreads very quickly, especially in multifamily units, from room to room to room. So the CDC, the EPA, all take this very seriously. And so I think that there is a need for this kind of regulation. I think that there are obligations in Senator Benson's bill on the tenant to respond, to provide the landlord access, and there are obligations on the landlord to do a very quick a remediation. Thank you.
Thank you, Mr. Chairman, members of the committee. Aaron Greenfield here on behalf of the Maryland Multi-Housing Association. We're here favorable with amendments. You have our written testimony. Addressing bed bugs requires engagement and notification by the resident. Without cooperation, bed bug infestations can result in significant financial and administrative burdens for housing providers, causing property loss, expense, and inconvenience. The central challenge we have is ensuring that residents have timely prepared their dwelling and their property. So in our written testimony, you'll see we request a couple amendments. One is to hold the resident accountable if the resident fails to properly prepare the dwelling, and if so, pursue a breach of lease action and require the resident to pay the associated costs. Also, this legislation assumes that certified applicators treat bed bugs on personal property. We're unaware of treatment outside of upholstered furniture and the unit itself, although I would defer to the pest control agents. Bed bugs indeed are introduced to units by residents. Legislation eradicating must properly balance responsibility for preventative action and eradication costs between residents and owners. When the resident fails to meet their obligation, the resident ought to have financial responsibility. And for those reasons, we respectfully request a favorable with amendments report. Thank you.
All right, thank you very much. All right, questions from the committee? Okay, Senator West.
This is the first time I've looked at the bill. I didn't see anything in it at first blush about who pays. Does the bill permit the landlord and the tenant to enter into a lease agreement providing for a fair division of the costs of eradicating the bedbugs?
It's a great question, Senator West. The legislation doesn't prohibit it, but in the event that a tenant does not comply with the responsibilities in terms of preparing the unit, under the initial draft, under this draft, the only remedy the landlord has is to seek injunctive relief. And there's some question whether injunctive relief would be permitted in district court, and if this would be handled as a landlord-tenant matter. There's some question there, but I assume if the legislature mandates it, it will in fact happen. But that's the one issue, is in order for us to pursue the tenant, we need to seek injunctive relief.
Actually, that was kind of along the lines, the question I had, Mr. Greenfield, is about the amendment. It was, sorry, it was, so what is to properly prepare the dwelling unit? What does that entail?
Yeah, so there is a process, again, there are better folks, there are people better able to explain this than me, but essentially there are time periods by which cleaning has to take place and preparation for treatment has to take place. That could include emptying of drawers and closets, placing clothes in plastic bags, vacuuming thoroughly, moving furniture from the walls, and about 30%, by our own data, 30% of residents are not prepared for this, which in turn, Mr. Chairman, delays the process.
We're all on a journey here with the bed bugs. That's how you're learning. All right. Additional questions from the committee? All right, thank you all very much. And with that, that concludes the testimony for the proponents. We'll now switch over to the opposition panel, and we have Mr. Washington.
Thank you, Mr. Chairman, and hello again. For the record, my name is Ryan Washington. I work on behalf of AOBA, certainly bedbugs is a huge issue across the state, and our housing providers take this issue serious, including not only bedbugs but other infestations, rodents, pests, and such. AOBA appreciates the bill sponsor's willingness to discuss the bill with the association, and we appreciate certain provisions of the bill that add language that requires a resident to notify a housing provider about bedbugs. However, there are still concerns we have with this bill as drafted. Senate Bill 529 creates a new standard for pest inspection and treatment for bedbugs by requiring a landlord to request an inspection from a certified applicator. Under current state and local codes, many of our housing providers already abide by laws that stipulate inspection and being held accountable for bedbug treatment and other infestations, not excluding just bedbugs. It is the housing provider's best interest to be aware of any presence of bedbugs on their properties. A lot of them do perform the initial inspection for bedbugs, and usually a lot of them do request the services and contract services to a certified applicator to go in and treat that unit that has been suspected or reasonably know has a presence of bedbugs. Senate Bill 524 sets bedbug infestations apart from other pests and rodents, and it creates a different standard of preliminary inspections. That's one of our main issues. We have specific changes that will make the bill improve upon and just clarify certain provisions in our testimony as stipulated. And thank you for allowing me to speak on behalf of this bill, and I will be more than happy to entertain any questions, ask any questions, answer any questions, sorry.
Excellent. Thank you very much, Mr. Washington. Seeing no questions, thank you.
Thank you.
And with that, that'll conclude the hearing and the testimony for Senate Bill 529. Thank you, Senator Benson. We'll next hear from, so Senator Huff, are you ready? Are you prepared? Yeah. All right. We can go Senator Huff. Senate Bill 435.
Well, thank you very much, Mr. Chairman, members of the committee.
I'll be brief as I guess this bill continues to re-summarize my relationship with the House of Delegates, because this bill has passed this committee twice the last 2 years. It's very simple. It was actually built off of legislation that myself and Senator Chris Schenck did years ago when I was in the House. But it's already a crime right now if you're a mandatory reporter that if you interfere with or stop the reporting of suspected abuse. All this legislation does is say that there is no statute of limitations now on that crime. That's all it does. It doesn't affect civil liability, doesn't change the actual penalty, just says there's no statute of limitations on that. So if any of you remember the Penn State scandal, it was built around that. We've actually had some instances of that are still coming out about abuse within the school system in Frederick County. So there's a number of these things that are going around that I think that with this law is needed, and as we grapple with child abuse and particularly with institutions that may have stopped or prevented the reporting of abuse, this would just make sure that these individuals can be held criminally liable going forward. So,
Excellent. Thank you very much. Seeing no questions for Senator Huff. All right, then we have another panelist. Is Lisa Jordan still here with us? And she had a favorable with amendments. So, seeing that she's not here at the moment, that'll then conclude the testimony for Senate Bill 435 and the hearing for Senate Bill 435, unless there are questions. Senator Hettleman, go ahead.
Thank you. If I could ask the sponsor a question. In Ms. Jordan's testimony, she is offering an amendment to change the crime from a misdemeanor to a felony. Just curious what the sponsor thinks of that.
yeah, I would hesitate to do that, given that we have, I think, the bill. I guess I would hesitate to do that. I think the bill's pretty common sense as it is. We've passed it unanimously. When you change something into a felony, I think there's been a hesitancy within the committee and the General Assembly to make new felonies, so I think the bill's good as it is.
With that, that'll conclude the testimony for Senate Bill 435. Senator West, did you have a question, or?
No.
You're just blinking. Okay, great.
Oh.
I don't know why.
There you go. All right, excellent. All right, are we ready for the next bill?
Nope.
All right, we're now waiting for Senator Rosapep and Senator Kagan. It'll be a minute or two before one of the two gets here. While we wait, we'll do another dad joke. How about that? All right. What do football players do when they're overheated? They stand by the fans. Oh, okay. We got one slow clap in the audience. One slow clap. There you go.
Requirement that no witness can be heard unless he first tells a joke.
There you go. All right, so here's the last one before Senator Kagan gets up. All right, so what would happen if Mr. Goodbar and Peppermint Patty had an affair? They'd have a baby Ruth. Okay, all right. All right, Senator Kagan, we were just telling bad, terrible jokes while we were waiting for a senator to arrive. So Senator Kagan, we'll go with you. Senate Bill 486, welcome to JPR. Good to see you in person.
Thank you. For the record, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. And the timing going back and forth among committees is still a challenge, but good to be back here and see friends and colleagues. This is a modest bill about fairness, access, and equity. The women on this panel, and any woman watching or in the audience, knows what it's like, especially at a athletic game, at a theater, during intermission, to wait in a really long line to go to the bathroom, while the men pop in, pop out. This bill would simply require that if there is one toilet, that bathroom should be able to be used by anyone of any gender, with a toddler, with a senior, with someone with disabilities. It should be accessible. We shouldn't have harassment, confusion, challenges, or long wait lines. This law is already in effect in New Mexico, in Illinois, in Maine, Vermont, and California. Some of these date back 5 years or more. Denver, DC, Philly, New York, and then in Maryland, it is law in Baltimore City, in Howard County, and has been introduced just today, actually, in Montgomery County. Salisbury, Maryland, has already passed it. And it is, as I've talked to people, even in this election year, even when some people might be nervous and looking over their shoulder, I've talked to several of our colleagues in purple districts, maybe with opponents, maybe with a challenge getting reelected, and I've talked to them about this bill, and they've all responded, this is a no-brainer. This is common sense. When we use a hotel room, when we use a hospital room, in our own houses, people of any gender use a bathroom when it is one toilet. Just want to do a couple of quick things, and then I will let my witnesses speak. The data, if you want data, women take an average of more than 6 minutes to use a bathroom, and to use a bathroom. When men wait approximately 11 seconds. That's a bit of a difference. So if all the restroom is labeled for any gender, it would come down to about 1.5 minutes, which is manageable. A lot of times, people haven't even thought about doing this. As soon as you raise it, and I have, as I've been working on this bill with Delegate Solomon, who's done a great job, and his staff, people just say, oh yeah, that makes sense. I've mentioned it at markets and at restaurants, where there's a men's room and a women's room. They're each one stall, one toilet, and yet they are labeled as women and men. It happened yesterday in Annapolis. And I asked to speak to the manager, and she looked at me, she said, oh yeah, why don't we do that? Let me talk to the owner. So I think this is not hard. It's family friendly. It helps people who have been abused, threatened, beaten up, who are transgender or non-binary. Let me just talk about penalties. They are modest, but show that we are going to seek compliance. The first time you get a warning, you get 30 days to put up a sign. All we are asking is that people put up a sign. It costs $10 or $15, and the sign should just indicate that this is a gender-neutral bathroom. The second violation would be $100 and $250 each for a subsequent violation. In Baltimore City, what they found is as soon as people were notified that there is a law, they complied right away, so they've not had to deal with any fines at all. The Restaurant Association is fine with this bill. Delegate Solomon has done a great job working with them. I just want to say a couple of quick things. First off, in Bel Air, we have testimony in your hearings, in your folders, that in Bel Air, the only place that the person who wrote in and submitted testimony, the only place that this witness felt comfortable going to the bathroom was Starbucks. And so this person spends their whole day figuring out when and where they're able to stop so they can relieve themselves. That's absurd. The amendment makes clear that the language on the sign does not indicate any gender. It just would simply say restroom, bathroom, or toilet, and a symbol that does not indicate any gender, such as a picture of a toilet. And I will just say that the League of Women Voters submitted great testimony. There's a lot of great testimony in here. I want to read from Jake Day, except it's not in the right place in the pile. In any case, there's great testimony here, and we have everyone from Free State Justice, Kennedy Krieger, League of Women Voters, the Commission on Civil Rights, Only Theater, Annapolis Pride, Unitarian Universalist Church, the Developmental Disabilities Coalition, and many, many more. So with this, I think this is modest, common sense, not a burden on our small business, and a big difference for women, for people with disabilities, and trans Marylanders. Thank you very much for your consideration. Happy to take any questions.
Thank you, Mr. Chair. I'm just trying to get it straight. So if you have a restaurant with 2 restrooms, each one has 2 stalls, this bill wouldn't apply.
Not at all.
So if you have a restaurant with 2 restrooms, each with 1 stall, then this bill would apply to both restrooms.
Correct.
If
Just
you
a
have
sign change.
If you have a restaurant with 2 restrooms, a 2-stall restroom which says women, and a 1-stall restroom with urinals, which now says men, you'd have to change the men's designation so that the women could pass by the urinals and use the stall.
Correct.
Okay, thanks.
And if women feel uncomfortable, then they can choose the other room.
Okay.
Thank you for your question.
Just to be clear, so that one that the women can choose with the urinals, that means that the men have to go into the bathroom with the women? I mean, I'm trying to make certain I'm understanding what you're saying.
So the example, the third example that Senator West gave was two toilets in a bathroom labeled women. That would not change because it's more than 1 toilet. This bill only applies if there is 1 toilet. If there's a urinal, that's irrelevant. It's just if there's 1 toilet. So in his third example, the other bathroom was simply 1 toilet and had a urinal as well. So if this bill moves forward, then that would be a gender-neutral, gender-inclusive bathroom, and anyone would be able to use it, and they would choose to use the urinal or not.
So are there situations where men and women are going to be in the bathroom together?
No, no, sir.
Okay.
1
Thank
toilet.
you. Very good, thank you.
And a lock on the door. There you go. So this is not about stalls, so it's not a single stall. It's really when you walk into a bathroom, think in a hotel room or in your own house, it's just 1 toilet. It would be that.
This is something that locals can do without us, though, correct?
There are locals that have already acted, Senator Huff. As I indicated, Howard County, Baltimore City, the city of Salisbury, and Montgomery County is starting it. There are a lot of other major cities that have done it around the country as well as other states. Sometimes, just like with the styrofoam ban several years ago when I sponsored that had already been law in a number of jurisdictions, but sometimes people need a little prodding, a little encouraging in order to move forward.
It's more than prodding. If we set the policy, we set it versus allowing the locals to figure it out. So is this bill based off of Montgomery County's policy?
No, sir, we haven't passed it. They haven't passed it in Montgomery County yet. Baltimore City was the first one, but Baltimore City was following D.C., Philadelphia, New York, and many others, as well as 5 states.
So this bill this is Baltimore City's policy now, what this bill is?
It is very similar to that which is passed in Baltimore City, Howard County, Salisbury, and elsewhere.
Baltimore City, Howard County, and, okay, Salisbury.
And Salisbury. Mayor Jake Day, who, Salisbury is not a blue area. Mayor Day feels really
Well,
strong.
I don't know about that. They got the university there. I think you might get a differing opinion
All right,
from the senator from Salisbury. I think that's the
Okay.
one little blue dot there.
Here we go. Here in Salisbury, we proudly proclaim that, quote, "all are welcome here." As mayor, I recognize that this is not just a tagline, but a clarion call to action, ensuring that all are indeed welcome here in our city.
Senator Castley.
Go here, but I will anyway. But
I mean, there's a reason we only take 11 seconds, because we're messy as crap. And no self-respecting woman would want to use a restroom that is predominantly used by males. So I just throw that out there. So if you have a sort of a classy restaurant that doesn't, if you have bars where people are going to the restroom constantly because they're drinking all night, but if you have a classy restaurant with two restrooms that are mostly not being occupied, and they try to keep the women's room nice and clean because women are clean, and we're, okay, I just,
So,
it's like we're treading into, you know, what is it? He who chases justice sometimes finds it. Be careful what you're asking for, because if you get it, it may not be what you really wanted, so just.
So first off, I think most women would trade a long line for a seat that's not put down again. Second, women are not universally clean, because we have all had the experience of coming in and a women's bathroom is not always pristine. And third, I will tell you, in Anne Arundel County, Stuart Pittman's family owns a lovely winery. It's very elegant. They have indoor and outdoor seating and all that. And I had a lovely visit at that location last summer. And Senator Riley's daughter works there. And I asked her afterwards, because they had a bathroom that was gender neutral. And I asked how many complaints she'd had. And she had worked there for 5 years. In her 5 years, and the bathroom predates her presence and her employment, in her 5 years, she had not had one complaint about somebody who wanted a gender-exclusive bathroom.
Excellent, thank you, Senator. Well, I didn't think we were going to have this conversation when I woke up this morning, but I disagree with your characterization. You can ask my wife. My mom raised you right, you know. That's one thing. All right.
And just to be clear, I didn't go deeply because I've got great witnesses that are going to follow, but people with disabilities often have caretakers of another gender. And it's awkward to figure out whether that person can come and assist them, and whether that's a senior citizen person with disabilities or a parent or caretaker of a child of another gender. It just all creates problems that can be so easily fixed with a sign.
Makes sense to me. Okay, excellent. Thank you very much, Senator. We'll now switch over to your panel. And we'll start off, we'll bring up Ed Zurarski and Maureen Van Stone, Alan Richardson, and do we have video testimony? Margot Quinlan, and then we'll bring up another panel after that. Actually, if we could start off, so if we could have Ed Zurarski go first, and then we could have Margot after that, and then we can go the rest of it.
So 2 minutes of dad jokes, right?
If you've got them.
I actually want to start, speaking of being a dad, with a statement from my 19-year-old son, who would be here today, but he's studying abroad in the UK. Since coming out as trans in 2019, the first time I felt truly safe walking into a men's room without the protection of my father or brother was when I saw a sign which actively welcomed me to use the correct bathroom. Because not only did I know I was allowed in that restroom, but everyone else had seen the sign saying I was allowed. There's a sense of security that comes with being reassured that you'll be safe and protected if anything happens. I still avoid public restrooms when possible, but in venues where there's a sign welcoming trans individuals to please use the bathroom they need, that fear of public restrooms goes away because I know that someone there has my back if something happens. That's why inclusive signage is important. I shouldn't have to fear using the restroom, and neither should anyone else. But I'm also here as a business leader. At Roundhouse Theater, we made this change to our single-stall restrooms 3 years ago and have had multiple patrons express their gratitude and not a single complaint. Just about every business covered in this bill is dependent on customers. That means our revenues, our successes, are dependent on creating an environment that is welcoming, safe, and accepting for our patrons. The more people we make happy, the better it is for our bottom line. And as the senator mentioned, so many people hesitate when facing gendered signage on single-stall restrooms. Parents with young children, people who are trans or non-binary, caregivers of a different gender than the person they're caring for. This is about the easiest, least expensive action that can be taken by business leaders to provide a more welcoming environment to a large number of people. It's not just the right thing to do ethically, it's simply good business, all for the cost of a couple signs.
Good afternoon, Chairman Smith and committee members. My name is Maureen Vanstone. I am the director of the Maryland Center for Developmental Disabilities at Kennedy Krieger Institute, which is Maryland's University Center for Excellence in Developmental Disabilities Education, Research, and Service. I appreciate the opportunity to provide testimony in favor of Senate Bill 486. My organization, Kennedy Krieger Institute, is dedicated to improving the lives of children and adults with developmental, behavioral, cognitive, and physical disabilities. Kennedy Krieger's services include inpatient, outpatient, school-based, and community programs like the Maryland Center for Developmental Disabilities. The Maryland Center for Developmental Disabilities mission is to provide leadership that advances the inclusion of people with intellectual, developmental, and other disabilities through pre-service preparation and training, community service and technical assistance, research and evaluation, and information dissemination. National data indicate that approximately 20% of the U.S. population is living with a disability. As a provider for individuals with disabilities, Kennedy Krieger feels strongly that all people deserve privacy and safety when using a public restroom. Gender-inclusive restrooms in public spaces are important for the patients, students, and families whom we serve at Kennedy Krieger Institute. A single-occupancy public restroom is defined as fully enclosed, containing only one toilet, and may be locked by the user. Often, the user of a public restroom, child or adult, is an individual with one or more disabilities who require a caregiver or a direct support professional to assist them with their toileting needs and to assure privacy by being able to lock the restroom door on behalf of the individual whom they are serving. In many instances, the caregiver or the direct support professional is not the same gender as the person whom they are serving, as Senator Kagan mentioned in her remarks. Additionally, gender-inclusive signage will create both a pictorial representation and descriptive language, such as restroom, bathroom, or toilet, which will be helpful to many individuals with disabilities across the state of Maryland. I urge a favorable report of Senate Bill 486 for gender-inclusive signage, and I appreciate your consideration of my testimony. Thank you.
Thank you, Senator, for your leadership. Thank you, Chair, Vice Chair, members of the committee. My name is Margot Quinlan. I'm here today as a volunteer with Trans Maryland. Trans Maryland is a multiracial, multigender community power-building organization for Maryland's trans communities. And I'm here today to lift up, as already been mentioned, that Maryland's trans and intersex communities face specific challenges when accessing basic bodily needs such as restrooms, healthcare, housing, and personal safety. This bill lowers that barrier to access. Gender nonconformity has existed since the beginning of time, and due to the violence of colonial systems, trans people are subjected to violence at higher rates, and this rate is even higher for Black and brown trans and non-binary people who face an almost 3 times higher risk of abuse in places of public accommodations than white trans people. Additionally, people who do not have a gender presentation, who do not have a binary gender presentation, are often forced to choose a non-affirming and potentially dangerous restroom, or to incur health problems like urinary tract infections as a result of being precluded from using a public restroom. Being perceived as entering the wrong restroom is dangerous, increases the likelihood of violence, and reinforces the minority stress disproportionately incurred by Maryland's transgender communities. This bill is crucial to ensuring Maryland can compete for business with nearby municipalities. It is important for people like me when I travel from my home in District 42 to Annapolis to be able to have access to restrooms along the way. And it is time for Maryland to demonstrate leadership in its values of non-discrimination and access for all. And for these reasons, we would urge a favorable report. Thank you.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher, and members of the committee. My name is Alan Richardson, and I'm here today in support of SB 486, the Open to All Act. I have resided in Maryland for over 70 years, and during that time, my wife and I greatly enjoyed going out to dinner and attending both theater and music performances in venues throughout Maryland. Unfortunately, in recent years, my wife battled both dementia and a severe loss of mobility. In spite of this, she continued to find great comfort in these outings, and they gave us the chance to retain an important part of our former lives. But there were problems. It was difficult for her, who had become easily confused, to manage trips into the ladies' room alone, and I became uncomfortable allowing her to enter restrooms by herself because she would forget where she was. Then later, when she became wheelchair-bound, she was completely unable to manage without assistance. Although there were sometimes restrooms accessible to those with disabilities, she could not use these alone. Often I had to decide whether to bring my wife into the men's restroom or to hire our daytime female caretaker for the evening to assist her. This added a layer of stress to our evening that we did not need. The Open to All Act would alleviate many of these problems by providing free access to all for single-use bathrooms. That would help us to manage by ourselves many of the problems we experienced. We all want to be out enjoying events in Maryland, and it goes without saying that none of us want to worry about how to access a restroom, regardless of our sex or state of disability. I thank you for taking the time to consider this bill and ask for a favorable report.
All right, thank you very much. Assuming there's no questions for this panel, we'll move on to the next panel. Thank you all for your testimony. Is Elizabeth Graham, and then we'll go Mark Eckstein, CP Hoffman. And then after this panel, we'll have a video from Ken Capone.
Hello, Chair, Vice Chair, members of the committee. My name is Elizabeth Graham, and I have lived in Maryland for a good majority of my life. I'm a volunteer co-facilitator with Maryland TransUnity Transgender Support Group, and I work full-time as a service coordinator for the Maryland Waiver for Children with Autism at the ARC Prince George's County, so I'm also familiar with Kennedy, Krieger, and some of the other issues people have already brought up. I'm also a transgender and autistic woman who does live within both of these communities. I'm speaking in support of this bill because it is important to have the gender-neutral signage for these single-occupancy public bathrooms. Many transgender people face danger in shared public bathrooms, as already mentioned. Early in my gender transition, there would be times I would avoid going to places that didn't have single-occupancy bathrooms, and I would go to places like Starbucks or Subway. And when I was a child, from the autism point of view, the shared bathrooms had a lot of sensory input, so the single-occupancy bathrooms were a safe haven from the overwhelming stimuli. And in the developmental disability community, as we have already heard, it is not uncommon for a child or someone to receive support from someone of a different gender. Governor Hogan has added funding for 100 more slots in the autism waiver and has done so in previous years. Statewide, we have 1,200 children enrolled in the waiver and 6,000 waiting to apply. This means more and more people with disabilities will be out in the community with caregivers. Also, please consider the times when you travel on airplanes, trains, or have used porta potties that even have a urinal. You're not worried about who came in before you. You just have to go. So it is likely that the bathroom said bathroom or lavatory, and most people don't mind lining up to use them. So please, I ask that you consider moving this bill forward and hope for a favorable outcome. Thank you. Any questions?
Good afternoon, Chair Smith and members of JPR. It's great to be here in person. My name is Mark Eckstein, and I'm a resident of Rockville and a neighbor of Senator Kagan. And so I'm very appreciative, and my family is as well, for her passion on this bill, and we feel it's very important. As we've seen in some of the testimony, a lot of states already have this law in effect. And when I talk to people from these states, they tell me that they didn't realize the broad effect of this bill. And as we've seen some passionate testimony here, certain minority communities, it is apparent that it will help. And when talking to these people, they're pleasantly surprised that this bill has such a broad effect. And then we usually end the conversation with something like, wow, this is such a no-brainer. So let's get this bill done. And to hammer this home, I just wanted to spend a couple seconds talking about my family and our experiences in everyday life. Over this past weekend, we went to Dunkin' Donuts, and my daughter, she's in elementary school, is waiting in front of the women's room for like 3 minutes. I'm like, what are you doing? I go over there, and she's like, I can't use the other restroom. I said, it's the same thing, just use the men's room, and she wouldn't do it, So then later in the weekend, my mom's in town, and we take her out to Chipotle. Same thing, same style of restrooms. My mom has some mobility needs and texts me to come into the restroom. I come in, help her out. As I'm leaving, I get some pretty aggressive stares. And so I think what we'll hear later is, in my case, these aren't terribly serious incidents in Rockville over the weekend, but data shows that incidences like these really lead to some serious crimes and some harassment issues. So therefore, I just am here to explain and hope for your consideration and a favorable report on this very important bill, Senate Bill 486. Thank you so much.
Thank you, Chair, members of the committee. The prior panelists have said most of what I was planning to say, so I'm going to attempt to be very brief. I'm just going to hit on 2 points very quickly. One is that one group that this bill will aid is actually fathers out with their young daughters, who frequently now face a situation where they're like, well, do I take my daughter into the men's room? Do I go into the women's room? And men, for whatever reason, tend to be very uncomfortable with this sort of question, as Mark just sort of hinted at. So this, by removing that designation that the single occupancy restroom is now, gender neutral, it will enable, a lot of fathers out with their daughters to sort of feel more comfortable going to the restroom with them. The other situation I wanted to raise were gender nonconforming women. There's a lot of women who have short hair, look very sporty, tend to wear, things that aren't necessarily traditionally like women's clothing, who are honestly the most likely group to be harassed about using the women's restroom. Because what happens is people see them and they're like, why is that man using the women's restroom? But it's actually just a woman with short hair or whatever. There's lots of reports of this that I could send to you if you really want to see some of them. But so this will actually help, just women with short hair, et cetera, et cetera. Finally, a just quick response to Senator Cassidy's question earlier. Clearly, you have not been in a women's restroom after the prior occupant has decided to squat and pee over the seat rather than actually sit, which is just truly a experience. So thank you, and I request a favorable report.
Right on time. Thank you, CP. All right, looking to the committee for questions. All right. Well, I'll just say this. We've got a video that we're going to play, and then that'll conclude the testimony for Senate Bill 46. While it's loading up, I'll just say, look, sometimes these relatively small things can go a long way in making us feel more inclusive, and I think it's just great. So thank you all for taking the time to testify.
Today I am representing people on the go and also the Developmental Disabilities Coalition. We are testifying in support of SB 486 places of public accommodation and public buildings, gender-inclusive signage. I, along with many people with disabilities, require daily supports. Like many people with disabilities do, I have two direct support professionals of the opposite gender who assist me with my daily needs. When we go out and I have to go to the bathroom, I usually have to wait until I get home if there's only gender-specific bathrooms available. And it's not good for anybody to have to wait to go to the bathroom. But if there were gender-neutral bathrooms available, I, along with my direct support professionals, would feel comfortable going in, and it would be better for my health. We are appreciative of the sponsor's inclusion of language requiring both text and symbol on any sign. This enables all members of the public to quickly identify the location of an appropriate bathroom facility. Thank you.
All right, thank you, Mr. Capone. And with that, that'll conclude the testimony and the hearing for Senate Bill 486. Thank you all very much. Thank you, Senator Kagan. All right, next we'll move on to, I think, is our final bill of the day, Senator Rosapep with Senate Bill 469. I think Senator Rosapep's Chief of Staff is going to provide the initial testimony. Welcome.
Hello. Yes, sorry, Senator Rosapep is tied up in another committee hearing, so he asked me to fill in. I am Owen Kahn. I'm his Chief of Staff, here to present Senate Bill 469, public access for courts, remote public access for courts. I'll be brief and hand it over to our expert witnesses, but basically what this bill does is it would require Maryland courts to have remote access as an option for the public. One of the few silver linings of the pandemic is learning that there are a lot of things we can do well remotely and virtually, like participating in hearings or work meetings or ordering food. So this bill is a part of the push to keep that virtual remote access an option for the public. And with that, I will hand it over to our witnesses. Unless there's any questions.
Can we please have Dr. Johnson? Welcome.
Good afternoon, Senators of the Judicial Proceedings Committee. I would like to thank Senator Rosapep for sponsoring Bill number SB 0469, Court Remote Public Access Act. I am the Director of Court Watch and Judicial Accountability. Subjectively, I stand before you today as an impacted woman whom was wrongfully convicted, and I suffer from extreme mental health disabilities, including PTSD and anxiety. As the Director of Court Watch, sitting in our Accountability Committee meetings, going over what our court watchers, law students, and community members have seen for the week, it triggers me, it hurts me, and some days it makes me cry. I often find myself drifting back to my trial days and how if there was remote audio-visual access available in 2015, maybe, just maybe, I wouldn't have been dragged off to jail. Some days in court watching, as I sit at my kitchen table, I hear loved ones waiting for bond hearings and waiting on their fate. I stand and I hear people begging for their medications. I hear them screaming that they're going to die inside there. I hear attorneys say how their clients have been sitting in a chair chained for 2 or 3 days and have not been processed into the jail. I've seen pregnant women stand before the judge for dead car tags, or they've stolen a bag of oranges to feed their 4 kids, and they live in a motel, and the pregnant mother was held on a huge bond. May I proceed?
Yes, if you could briefly conclude.
Thank you.
Thank you.
I've had the opportunity to sit in many court hearings, and we have community members that court watch with us that are hearing impaired, that have disabilities, that are retired, and they also are able to sit at home and be able to court monitor. And I'm nervous now, but what I'm asking today is that this bill be passed, and this bill will represent accountability that go on in the courtrooms and transparency. And maybe, just maybe, what happened to me will not happen to anyone else. I apologize for taking up so much time, and I hope that this bill become favorable. Thank you.
I appreciate it. No apologies necessary. Thank you for your testimony. All right, next we'll hear, well, actually, whoever wants to get up.
Good afternoon, members of the committee, Mr. Chairman. I appreciate you guys for taking the time today. My name is Edwin Whitehead. I'm with Court Watch PG. I am, depending on the day, either the left or right hand of Dr. Carmen R. Johnson sitting to my left. The importance of SB 469 is, one, it is a constitutional obligation for us to have public access to our courts to begin with. That's something that I'm sure everyone knows in this room because there's a lot of lawyers sitting here. And secondly, we have a judiciary in many, many states, not just here in Maryland, but all over the country that fail in this department of transparency, accountability, and the egregious acts that they commit to communities, usually of color, every day. I think the biggest thing for me is to see folks who have committed either little to what would be considerable as something minuscule, and it goes by the wayside, or they're not supported in any way, shape, form, or fashion. This bill allows us to do that. More importantly, folks who have everyday, common, regular lives get a chance to, even on a lunch break or what have you, have the opportunity to not only just show up to court, but be accountable for themselves and prevent themselves from having to get failure to appear or a warrant over their head. In the time that we've had these virtual proceedings, we've seen FTAs drop significantly. We've seen numbers of pretrial go up simply because a family member can be present. The bigger part for me is seeing a bunch of grandmothers show up to court because they're the ones who usually can take their grandchildren into pretrial. And so for me, it's just to repeat what Carmen said, injustice happens in an empty courtroom. And this helps us prevent that from ever happening to anyone else or people who look like me ever again. Thank you.
Is this mic on? Good, because I'm going to sit here and do my test.
Actually, if you could so the camera can catch and so everyone member of the committee could see if you're able to.
I'm going to try. I'm not feeling the best today, but I'm going to try.
Ma'am, go ahead. You can take a seat then. If you're not feeling well, don't worry. Yeah.
Yeah, thank you. I try to stick around. I'm going to leave straight here and go home. But my name is Kiana Johnson. I'm the executive director of Life After Release and founder. And I am also a co-founder and co-conductor of Harriet's Wildest Dreams, located in Washington, D.C. And I'm coming here today to stand behind this bill. And I thank you all here today for actually hearing us out on this bill. It's very, very good legislation. It's bipartisan, right? And Court Watch PG is actually a community program of Life After Release, a community program that was actually born out of a need that we needed to actually watch the courts around ending cash bail. But then we ended up here, we had a pandemic occur. And during the pandemic, what we noticed was that virtual access to the courts was probably one of the best things that this pandemic has left us with. And I'm not the only person in this that actually believes this. If you take a look at a published report by U.S. courts that was published on February 18, 2021, the title being As Courts Linger, Lean into Virtual Technology Due to the Pandemic. And so there were several U.S. judges that actually believe in this. And so I encourage everyone here to actually take a look at this report and to actually understand that Maryland is actually
at odds here. We also run a participatory defense program, and I have been all over the state attending court with individuals throughout this pandemic to help them navigate the criminal legal system. I was in Worcester County where I had a judge tell me that I had to have a motion to actually come into the court during the pandemic. They have zero access. Baltimore City has zero access. And these are all different jurisdictions in which I wanted to go and support someone with their court cases and was unable to do it because there's jurisdictions in this state that do not have policy to tell them what is good and what they should be doing. And so as we saw in the compelling video here for the testimonies before us, we were able to see that because we had access to that testimony. And it was a very compelling testimony that we all needed to see here today. And so what I'm asking you today is to grant us that access to the courts. Thank you.
Thank you very much. All right, thank you to the initial panel. We'll now hear from, let's go down, Ms. Hanson-Mandel, Joanne Anthony, there you go, Jade Eaton, and can we have Rebecca Snyder? Sure, hold on, wait, so it's not distracting for you when someone else comes sit down. Be good.
Good afternoon. For the record, Nicole Hanson-Mundell, Executive Director of Out for Justice. I don't want to take too much time. One of my closest allies just kind of gave you all a very compelling argument of why we need access to the courts. We know that your neighbor in town in D.C. has access to the courts. They use remote court on a regular basis. So in fact, we're kind of behind in terms of remote access. Over in the House, they're discussing remote access. And so I think this is the year that you all have to make some decisions around opening up access to the courts. It is a place where constitutionally we all should have access to the courts, and because of individuals' inability to drive or whatever the inability is, a lot of citizens just don't have the access that they need to the courts. Lastly, a lot of the barriers, this would prohibit a lot of people from going to jail. These barriers include lack of child care, lack of transportation, chronic health conditions, and restrictive work hours that make it difficult to attend hearings in person. And so being able to attend remotely from a mobile device allows many individuals to circumvent these barriers. So I'll give the rest of my time to my colleague too, but I hope this is something you all get on board with, because it's inevitable and we need it. Thank you.
Good afternoon, Chair Smith, Vice Chair, and members of the committee. For the record, my name is Joanne Antoine, Executive Director of Common Cause Maryland, testifying in support of SB 469, which would retain the virtual access that we have in our courts right now. I don't want to be too repetitive. I'll keep my testimony short. I think at all different branches of government, at all levels of the state, I think, the pandemic has allowed us to, put in place transparency that should have been in place many years ago. We've seen that here in the legislature, where we have managed to get meaningful engagement throughout the legislative process. And you've heard from court watchers and family members who have been able to tune in for proceedings where they are helping individual plaintiffs or where they are just tuning in to support their family members. I think we should be working to learn from the pandemic. And I really think this is a very simple, straightforward bill. As virtual access or Zooming in, becomes the norm, we should adjust our protocols to be in line with them, and we'd urge a favorable report. Thank you.
Good afternoon. I'm Jade Eaton. I live in Greenbelt, and I'm a volunteer for CourtWatch PG. And I urge you to support SB 469. In the past few years, I was weighed down by the enormity of the inequities in the criminal justice system that I read about in books like The New Jim Crow and I saw on the news. but I couldn't see how I could make a difference until I heard about court watching. Observing actual court proceedings has given me an education that all the books on mass incarceration could not, because it brings the system down to human scale. And this was made possible by remote access. How else could I know that jails are close to capacity with little chance for social distancing and still full of COVID cases? Or that the pretrial services office is overwhelmed and people are sometimes held weeks before consideration for release can be processed? Or that minors were being held in adult facilities pending trial because of overcrowding and understaffing in juvenile facilities? How else could I tell you, my state representatives, about these issues? The more people that can observe court proceedings, the more likely it is that you will learn about conditions that need change. The reality is that access to courts right now is not equal. The costs of traveling to be physically present fall disproportionately on lower income people. Once there was no alternative to traveling to the courthouse, but now most people could connect to court with just their phone. There is no longer any excuse to deny people equal participation in the justice system just because they cannot appear in person. I urge you to give a favorable report, and thank you for your time.
Good afternoon, Chair and members of the committee. My name is Rebecca Snyder. I'm the Executive Director of the Maryland-Delaware DC Press Association, which represents most news media in Maryland. And we are here in support of this bill. As previous panelists and proponents have said, the world has not fallen apart because we have had remote access to the courts, and it's a necessary step to preserve that access that we've had, the silver lining of COVID, if it, as you will, to allow people to interact with the court system. For the journalist aspect, I think it also is critical because it allows our reporters to cover a wider swath of cases and proceedings than they might ordinarily be able to cover. I think this bill also balances quite well because any party, witness, or counsel could ask the judge to prohibit the broadcast. So if one is physically able to attend, you would be able to see the proceedings, and now it just eliminates that barrier of access. So we do urge a favorable report. I would also direct your attention to the 2016 report I cite in my written testimony, the video recording courtroom proceedings, the report on the pilot project. This is tried and true. Maryland is behind the times, and I urge a favorable report. Thank you.
Excellent. Thank you very much. All right, next we'll hear from Daniel Daugherty-Weiss and Mr. Denibber.
Thank you. As he said, my name is Daniel Daugherty-Weiss, and I'm testifying in support of the bill to guarantee virtual access to court hearings. And through my direct observation of bail hearings in conjunction with Court Watch PG, I've become convinced a more just court system will depend on increased access, continued access that we've had, transparency and accountability. Before I became a court watcher, I thought I was a well-informed citizen, as Jay said. I assumed that Maryland, my county in particular, was probably doing just fine when it came to bail hearings, but some of my church members convinced me to check this out. This is a worthy thing. Prince George's County had elected a progressive prosecutor with a no-cash bail policy. However, upon going to some of these hearings and reflecting on them, it became clear that our courts continue to reflect biases and incentives towards unnecessary pretrial incarceration of poor and working class individuals, and that these conditions continue to prevail even in Maryland, where past efforts at reform have allowed judges to ask for only 10% or no cash up front to back the accused promises to appear in court. I was shocked to find that we routinely jail citizens, even when technology allows us to monitor the accused location 24 hours, 7 days a week instead. I observed that despite their arguments of competent public defenders, the scales seem fundamentally tipped, not only against poor and working class individuals, but also against our common good. In my written testimony, I provide specific examples of unnecessary and harmful pretrial incarceration that surprised me. They may surprise you as well. I am a rare concerned citizen in the county with the flexibility to observe during business hours, and yet even for me, the drive to the county seat is a major impediment to serving as an observer. In fact, I didn't start until this was allowed in quarantine. So I can assure you that the public, without data systematically and openly collected by groups like CourtWatch PG, the public will never know that the freedom of the accused in our courts depends on the whims of who is sitting on the court bench on any particular day. We need virtual access to understand what our state is doing in response to legislative reforms and elections. Thank you for your time.
Okay. Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. DePaul Nibber on behalf of the Maryland Association of Counties in support of SB 469 with amendment. To be clear, our counties have no opposition to the underlying intent of this bill. There is, however, a potentially substantial and unanticipated cost to our circuit courts, which are funded by counties, in terms of retrofitting their courtrooms with AV equipment capable of live streaming proceedings. And so we've offered an amendment in our testimony that is before you today, and we urge a favorable with amendments report for SB 469. Thank you.
Excellent, thank you very much. We'll turn it to the committee for questions. Senator Sidnor.
I know the sponsor of the bill, actually, if you wouldn't mind.
Yes, I might have to pass it off to one of our witnesses, but sure, go ahead.
Well, I'm just a little confused because I guess from reading the bill, I thought that the bill was essentially just talking about opening up the court so that the public could see what was happening in the courts. But then as I was listening to testimony, it seemed to be much broader than that because I heard people talking about participating in the court hearing. So I'm curious, what is the intent of the bill?
This is just for public access.
What does that mean?
Not for participation.
So just watching?
Correct. Just
Thank you.
audiovisual.
Okay.
Watching.
Thank you.
Yes.
All right. Additional questions from the committee? All right, with that, then that'll conclude the testimony and the hearing for Senate Bill 469. And our hearings for the day. First live in-person hearings since March of 2020. All right, that's it.